We've got quite a bit of sanctions and docket activity and the whole 9 yards going on with the Fat Joe lawsuits. Remember, there's the original lawsuit and the what we're going to call the counter lawsuit. And we've also got some updates on Tyrone Blackburn's criminal case and some other civil proceedings that he's an attorney for various other plaintiffs or defendants in that have had some interesting updates as well. So this is going to be a very docket heavy stream. The centerpiece is going to be Alex Spiro's latest filing on behalf of Roc Nation. It's a motion for sanctions, including a dismissal with prejudice for Roc Nation as a defendant in the Terrance Dixon lawsuit. And remember, Tyrone Blackburn represents Terrance Dixon. It's been a while, so I thought it'd be helpful. Let's speed through the timeline of how we got here. This starts all the way back on April 29th, 2025. So just over a year ago at this point. Fat Joe files his lawsuit. This wasn't as heavily reported, but Fat Joe filed a lawsuit first against Terrance Dixon and Tyrone Blackburn. He's like, look, my former hype man, Terrance Dixon, is saying all of this crazy stuff online. His attorney, Tyrone Blackburn, is in cahoots with him. This is not just defamation, but it's also extortion. So they file this lawsuit. On June 19th, Dixon files his lawsuit against Fat Joe. This one got a ton of coverage. It was extremely salacious. He's seeking like $20 million. He not only names Fat Joe, but he names like Roc Nation, Erica Morera, who's an attorney for Fat Joe, and a bunch of other artists, personalities, management teams, and companies. Not only does he allege that, hey, Fat Joe owes me money, but he alleges a civil RICO between all these parties. He also claims that he was forced into thousands of sexual interactions, sexual situations by the defendants he names. And then he alleges that Fat Joe and others were engaging in sexual activity with minors. Very salacious stuff that made headlines. Let's see. Right after that, Roc Nation, like Alex Spiro, came in right away and filed a motion to dismiss. That was a pretty big filing a lot of people paid attention to. Not just because it involved Roc Nation, but because Alex Spiro pointed out that in communications, Tyrone Blackburn was saying things to the effect that, we know your client didn't know this was going on. We know that your client didn't take part in this. And we also, my client, Terrance Dixon, has nothing against you, Roc Nation. And that type of sentiment is kind of odd to say to somebody that you're suing for doing and knowing about those exact things. So Alex Spiro's like, Roc Nation has nothing to do with this. And it seems like the opposing counsel is conceding as much. So that was a pretty big lawsuit. And again, a filing. And again, that was a year ago at this point. March of this year, we're going to skip over some of the discovery and sanctions drama that we've already covered in previous videos. There's a playlist in the description. But in March of this year, after no response for a very long time, Terrance Dixon in Dixon v. Fat Joe and everybody else, the counter lawsuit, after not responding, he asks for time to amend his complaint. And the other parties opposed. They're like, why would you give him this opportunity? But the judge allowed it. So this new lawsuit files in by Dixon. It's amended, and he drops these major RICO claims. So suddenly this complaint looks very, very different from how it initially looked back in June of 2025. A lot of the allegations about sex with minors are removed. The trafficking claims, a lot are removed. And the RICO claim is just like absent. Like, where's the RICO? And now it's mostly about money and business and contract disputes, royalties, unpaid dues, all of that. So all of that fuss that made the headlines last year very loudly is missing from this amended complaint filed by hypeman Terrance Dixon. And then that catches us up. We are in May. We're going to get caught up with the May happenings. We last left off, again, if you want to go into detail on any of the previous sanctions fights, because I think there's 3. I think there's 3 at this point running within these 2 cases. We were up to docket item number 191 in our last video, which takes us to May 13th. This next filing here on May 13th, 2026, and it's a letter from Jordan Sieve. We're going to breeze through some of this stuff. just so you guys get the lay of the land and where we left off. But I think the star of the show is going to be Alex Spiro's filing. So let's get this letter quick. This is May 13th, so we're traveling back in time a little bit to get caught up. This is Jordan Sieve. This is counsel for Fat Joe, saying, Judge Rochon, we're writing to bring to the court's urgent attention yet another instance of defendants Terrance Dixon, Tyrone Blackburn, and T.A. Blackburn Law willful refusal to comply with the court's directives. This time, Your Honor's order dated April 24th, 2026. That's the last thing we left off on. In the order, the court held defendants in contempt for failing to appear at the court-ordered depositions on February 6th and 9th. The court directed defendants to pay plaintiff the reasonable costs incurred, to pay the videographer and court reporter for the February 6th and 9th deposition dates, within 10 days of receipts of their invoices. Defendants have disregarded the order entirely. You could, I don't know if it's just me, but you kind of get the sense that somebody's like writing this with a pen that's on fire. Pursuant to the order on April 27th, 2026, plaintiff sent defendants a letter annexing invoices, showing that plaintiff incurred $2,585.45 in costs for the videographer and court reporter for the February 6th and 19th deposition dates. They show that as Exhibit 1. As required by the order, plaintiff demanded that defendants pay that money via wire to Reed Smith's client trust account, that's the law firm, by May 7th, 2026, 10 days later. The court's deadline's now passed, and defendants have completely ignored both the order and plaintiff's demand. Plaintiff received neither payment from defendants nor any response whatsoever to plaintiff's letter. Although plaintiff's counsel sent defendants a follow-up email on May 11th, 2026, defendants once again failed to pay or even acknowledge their obligations, and they attach that as Exhibit 2. This pattern of deliberate noncompliance cannot be permitted to continue. And it's almost, to me, it's like cliche. Like these attorneys keep saying this pattern, particularly that Tyrone Blackburn is engaging in. You can see this across cases where he represents different clients. But attorneys, opposing counsel in all these different cases seem to have to ask over and over and over, like, stop letting this attorney continue in this pattern of behavior. Like these phrases, I feel like I see in all of these motions across multiple cases. They say defendants have flagrantly violated the order and demonstrated their contempt for this court's authority. Further contempt sanctions are not only warranted, but necessary to compel defendants' compliance and deter future noncompliance. Plaintiff therefore requests that the court order defendants to show cause why they should not be held in contempt for this additional violation and should not be subject to additional sanctions, including requiring defendants to pay all of plaintiff's fees and costs incurred in connection with this letter. We thank the court for its attention to this matter. Respectfully submitted, Jordan Sieve. So back over to the docket right away. Judge Rochon entered an order to show cause. It's just nice and short. So here we have, hey, on April 24th, I held you guys in contempt for failing to appear at these depositions and ordered you guys to pay the costs. On May 13th, Jordan C. filed this letter saying you haven't complied with the court's order, and you're ordered to appear on May 20th to show cause why you should not be sanctioned. So the judge did issue that right away. And in between all that, we had some motions to dismiss come in. And one thing worth noting here, if you wanted to go and check out the dockets for this case, since there's the cross filings, they were merged together, but it's not a perfect merge. These motions to dismiss coming from parties like Richard Jaspitre, I don't know how to say his name right, Erica Morera, all these other companies are really in relation to the complaint that Dixon filed. They're supposed to all be merging on one docket, but that's not always the case. There is still the Dixon v. Cartagena docket where a few things periodically like this, May 20th, are popping up on the docket. So if you're looking at this on your own time, just hop over to both, because you might realize that, hey, something's making it on one docket but not the other, or it's on a docket you think it'd be on one, but it's really showing up on the other. So kind of confusing, but just so you guys know. And we're going to skip these, but I wanted you to know, we could read them on another stream if you guys are interested, but I wanted you to know that they were coming in at the same time. So you have all of these parties writing in their motions to dismiss the amended complaint that Terrance Dixon filed that removed all the RICO and all of the salacious material. Then on May 15th, we have Jordan Sieve file a declaration for the motion to dismiss. If we were to do a stream, this would be the bulk of what we would read. It's really all the tea. And then we've got, let's see, the order for the oral arguments. So this is a different sanctions motion, you guys. So this is why I said it gets confusing. So on May 18th, this is, let's see, where was it? They have a sanctions motion, and I wish we could have watched it, but this is New York. There wasn't really anyone with a camera in there, and there was no public call-in hotline. But May 18th was the hearing for sanctions related to the web of cross-sanctions. So when Tyrone Blackburn and Terrance Dixon finally did sit for depositions, right? This is separate from the sanctions and costs related to the failure to show. When they finally did appear, they were not really answering questions. Things got off the wall, really. They kind of went completely to left field. And Fat Joe's team wanted sanctions for the behavior that occurred during those depositions. And in response to that request for sanctions, Tyrone Blackburn filed his own cross motion for sanctions, and it's been an ongoing battle. Check that out in the playlist in the description. But that hearing happened on May 18th. So you have all these different sanctions and contempt things going on. Let's see. And then let's see. Then we get to the order to show cause, which was dealing with the payments that weren't being paid. So here we go. He was supposed to show cause. And there's one thing I wanted to go in between. Before we had this file in, there was this other update in a different case. It's a case where Tyrone Blackburn is representing someone that's accusing Diddy of wrongdoing. And it's in front of Judge Mary KV. And I saw this hit the docket after it was filed, but it was around the same time as Jordan C., Fat Joe are requesting this order to show cause. But I saw this and I was like, here we go again. So in this separate case, the attorneys for Sean Combs write the judge. While all this is going on in the Fat Joe cases, they're like, hey, we're the attorneys for defendant Sean Combs. We respectfully request clarification of the court's April 24th order, in which the court accepted plaintiff's untimely opposition to Mr. Combs' motion to dismiss the complaint. So the plaintiff in this case is represented by Tyrone Blackburn. That opposition was filed on December 25th, Christmas Day, as an exhibit to attorney Tyrone Blackburn's letter requesting leave to file plaintiff's opposition to defendant's Rule 12b6 motion beyond the court order time limit. So the party here, Diddy's attorneys are like, hey, you gave them this permission to file this late, but you didn't explicitly say if we have an additional time period window to reply to whatever they file, right? So can you give us that? And if the default schedules under Rule 6.1 apply, can we have an extension to file our reply from May 1st to May 8th? This would be our first request for such an extension. After reviewing the April 24th order, we attempted to contact Mr. Blackburn to obtain his consent for an extension, as is required under Rule 2G of the court's individual rules of practice. Now, a lot of these judges, we've seen this with Judge Rochon in the Fat Joe cases, they have their individual rules. When you file something, you apply for admission in a certain case, you get a copy of that judge's rules, and you should listen to them. I don't see why you wouldn't follow them. But a lot of the judges, including Mary V., including Judge Rochon, say, look, the parties should do their best to try to confer with one another before bothering the court. Have some decorum, have some civility, and handle your business. And if you need a mediator, if you need a referee, then send a letter to the court and we'll set something up. And it's been a repeat pattern where Tyrone Blackburn will not reply, will not follow these court rules. So here they say, they tried to ask Mr. Blackburn, hey, can you just stipulate to this extension? You're going to file late. We need the additional time to reply to whatever you file. This is required. We have to ask you first. Tyrone Blackburn responds with no. Just a one-word response with no explanation. And then they complain that the opposition exceeds the page limit by 11 pages and is not double spaced, which is another way to get around a court-ordered page limit. He spaced it instead at 1.5 lines, effectively expanding its non-compliant length even more. We therefore respectfully request clarification whether the court will consider the entirety. Let me get the next page. And if so, whether the court will permit us, Mr. Combs, to corresponding reply with an enlarged reply page, as may be necessary. So they ask for those two things. The judge order in reply says, in light of the court's decision to consider plaintiff's untimely opposition brief, which also does not comply with the court's individual rules with respect to length and the spacing of memoranda of law, so they agree Tyrone Blackburn's filing does not comply. Defendant is, of course, entitled to file a reply brief. The reply will be due May 8th, so they give him the extension. The request for enlargement of the page limit is granted. The parties are on notice that failure to comply with court orders, the court's individual rules, the local rules, and the federal rules of civil procedure may result in sanctions, including monetary sanctions on counsel and the parties themselves, preclusion of claims, defenses, evidence, and motion practice, and the case terminating sanctions of dismissal and default judgment. Plaintiff is on notice that he's ultimately responsible for prosecuting this case. And this was Burroughs. This is the case, I think, with Burroughs suing Diddy. So plaintiff's on notice that you're ultimately responsible for this. And this could be dismissed or otherwise adversely impacted by his chosen counsel's conduct. So, Mr. Burroughs, you're on alert that Mr. Blackburn's behavior could get you in hot water. The court directs plaintiff's counsel to inform his client of this warning. The court also admonishes plaintiff's counsel to exercise more reasonable professional judgment in his dealings with defense counsel. So there's that. There is that. And as you guys can see by this sidebar here, this is April 27th. This is sorted by latest. This is how many updates I've posted relating to Tyrone Blackburn. Look at the scroll bar. Look at the scroll bar. Since April 27th. So we might hop around a few of these. Some are related to Fat Joe, but not all of them. This one on May 7th at .. star. Shout out to him. He's the GOAT. Notice that in the case of Liza Gardner, another case where Tyrone Blackburn is representing a plaintiff against Diddy, has been ordered by the judge in that case, Judge Gordon, to show cause for why he should not be held in contempt for failing to follow the court's sanctions order regarding AI misuse. So in another case, opposing party was awarded, their motion for sanctions against Tyrone Blackburn was granted. The issue was AI misuse in pleadings and filings. And the judge said, look, why now you haven't made good on the payments. You were already ordered to pay these sanctions. You're missing your payments over in the Gardner case. And now, because you're missing the payments, we want you to produce your financial records to demonstrate why you have this lack of ability to pay. So that was happening on May 7th. God, there's so much. On May 10th, a different case here. And this one might get its own stream. This is United States v. Luo. It's like a fraud case that's going on. There's a criminal prosecution happening. And because this criminal prosecution's happening, there's a little bit of throwing under the bus going on. And we're not going to get into the weeds too much on this case, but just know that someone who was a client of Tyrone Blackburn, who is now under indictment. So Luo, the client, the former client, is now under indictment. She's questioning why her former attorney, Tyrone Blackburn, is not also being prosecuted. So there is a whole mess going on here, and a little bit of that. So many cases. We'll read a little snippet here so you can see if this tracks with the usual MO. So here it says, crucially, once the mediator was unable to negotiate a settlement in the civil proceedings where Tyrone Blackburn was representing Luo, Victim 1 contacted the defendant directly, asking that the defendant meet Victim 1 in person to talk. But the defendant was not interested in blackmailing Victim 1 or squeezing money out of him in non-legal ways. Instead, she, Luo, retained counsel. The lawyer that she retained was Tyrone Blackburn, an attorney based in New York City. This, more than anything, was the defendant's biggest mistake, as all communications prior to Mr. Blackburn being retained remain confidential and with an aim towards a resolution. Once Mr. Blackburn was retained, he escalated the nature of settlement negotiations, making statements, allegedly on behalf of Ms. Luo, that the government found to be extortionate. Unbeknownst to the defendant, so Luo saying, "I didn't know my attorney was doing this." Mr. Blackburn has engaged in an unethical manner of practicing law, threatening a multitude of individuals with the publishing of false allegations under the cloak of the judicial system, and using shakedown tactics that masquerade as lawyering. Defendants in this district have noted this attorney's improper and unethical behavior. So we get the same. All of the attorneys that have some trouble with Tyrone Blackburn always cite the Honorable J. Paul Otkin issuing a warning to Mr. Blackburn because his filings, quote, "are replete with inaccurate statements of law and full of similar irrelevant insults, misstatements, and exaggerations," from the Jones v. Combs case. The next screenshot in that one, let me blow it up. And why she's upset, like, why are we not prosecuting Tyrone Blackburn? So here's another little bit here. The government's response largely ignores the defendant's primary legal argument, that the conduct alleged is not wrongful. And as detailed in the defendant's motion to dismiss, prevailing jurisprudence dictates that a threat to expose or file a lawsuit is not extortionate if the defendant has a claim of right of the property demanded, and the threat is directly related to that claim. So they're saying here that indeed the government doesn't dispute that victim 1 transmitted HPV-16 to Ms. Luo during an illicit sexual encounter, nor that this transmission formed the basis for her legal claims. So the things that Ms. Luo was willfully trying to litigate, the government isn't disputing. So then she says, because Ms. Luo had a direct claim for damages resulting from this injury, her attorney's threats to pursue litigation or criminal charges do not meet the wrongfulness element required for extortion. These threats were not false statements or material misrepresentations. They were adversarial advocacy in support of a favorable financial settlement outcome. Moreover, the government's silence on the claim of right defense suggests they cannot prove the necessary elements of wrongfulness in the context of a legitimate personal injury dispute. In addition, the government offers no comment or justification for their selective prosecution of Ms. Luo, and it fails to explain the glaring disparity in its charging decisions. It's undisputed that the most aggressive and extortionate statements cited in the indictment were made by Ms. Luo's then attorney, Tyrone Blackburn, almost exclusively outside of her presence. Despite having a documented history of problematic tactics and conduct in this district, get the final screenshot. Oh wait, does it just scroll down further? Okay, never mind, it's here. As well as being the primary actor in the communications the government labels as criminal, Mr. Blackburn remains uncharged. Although not explicitly argued, the government's assertion that Mr. Blackburn indicated to Victim 1's attorney that Ms. Luo, quote, directed him to convey certain demands to Victim 1 attorneys would certainly not shield him, or any lawyer, from participation in an otherwise extortionate scheme. Moreover, the government's response provides no explanation for why it has targeted the client, who surely relied on counsel's advice, while ignoring the attorney who actually formulated and delivered the statements. This court should require it to do so. So that's happening at the same time as some of this sanctions mess going on. That was May 10th that I posted about this. This was filed February of this year. So very busy during, Tyrone Blackburn took that cruise. He was on rest and recovery. His narcotics regimen wasn't doing anything for 6 to 8 weeks or whatever. But this was all happening earlier this year during that time period. So sure, he had a lot on his plate. Let's see what else we had. May 10th, we also had if you guys remember the Fazia Abashi, her case against Livingston Allen, DJ Academic's real name. Tyrone Blackburn represents Abashi, and ... noticed that her case was dismissed without prejudice, which means she can refile, because we were missing deadlines. So let's open this up big. So this was May 8th. It was actually filed. Plaintiff's complaint is hereby dismissed without prejudice for failure to comply with discovery, pursuant to Rule 423-5. The plaintiff shall appear for her deposition anyway on May 14th at the office of the law firm. And then there we go. So she's able to refile, but does that sound familiar? We file a case and we're not complying with discovery. That's been a major, major issue with the Fat Joe cases. And let's see, I'm telling you, there's so much. On May 11th, in the Kirk Burroughs and Sean Combs Diddy case, let's see, they had a footnote. We had footnotes for Attorney Blackburn. Do I have this clip? I think I might have an important clip here. This is what's happening.
So many cases, I don't know. I just can't it's like a lot of cases.
Like, and this is all of them. Like, not all of them, literally, but they're all hot messes. The ones that I've been able to take a look at all have some type of hot mess going on. Like, nothing can just be normal litigation. So let's see here. I don't remember why I tweeted this, but if I tweeted it, there was something interesting, and it involves a footnote. So first up, we have, it's from a reply memorandum of law in support of defendant's motion, so Diddy's motion to dismiss the complaint, or in the alternative, to stay the action and strike scandalous and irrelevant material. So here, what I had highlighted, we'll just jump to what's highlighted here. So they note down here that plaintiff's opposition raises concerns about its genesis based on its language and tone, as well as several arguments made that are not addressed in the motion to dismiss. And then they cite here a different filing where in Gardner v. Combs, Mr. Blackburn was sanctioned because he cited to a non-existent case and fabricated legal proposition derived from generative artificial intelligence. So this is where we saw the $6,000, and he was ordered to pay and then was late on payment, and the Combs party in that case wanted to hold him in contempt, and the judge ordered him to show cause. So this is being cited in this different Burroughs case. They say, given Blackburn's self-disclosure of his use of AI, along with his misrepresentation that he's taking continuing legal education courses on the topic, the court declines to impose sanctions at this time. The court does, however, caution Blackburn that providing submissions to the court with inaccurate and false information violates the New Jersey rules of professional conduct. This is a different cases from Jones v. Combs. And then the court finds much of Blackburn's conduct to be unsettling. Blackburn's filings are replete with inaccurate statements of law, conclusory accusations, and inappropriate ad hominem attacks on opposing counsel. That's that Paul Otkin order. And then, let's see. All right, so the next two pages that I quoted, let's see if you guys recognize the playbook. So they complained for about a page and a half that, look, this was otherwise outside the statute of limitations, with the exception of New York State. They have this gender-motivated violence act that comes about that renews a window where you can bring claims forward. And they say, like, look, plaintiff cannot even identify the day, month, or year when something supposedly happened. They don't plausibly constitute a qualifying crime of violence under that GMV. A bear hug or fleeting over the shoulders, over the clothes touching on a city street is not a sexual offense, nor does the complaint plausibly allege that the conduct was motivated by gender-based animus, as the statute requires. So here's all these flaws and why this claim should be dismissed, and this claim is the only reason why this is allowed to be brought, because otherwise the statute of limitations would have run out. So they say plaintiff's effort to revive this stale GMV claim will not succeed because the GMV revival provision is preempted by the comprehensive statewide framework enacted by the New York State Legislature. That legislation established a limited and exclusive revival window for ASA, Adult Survivor Act claims, based on sexual offenses under Article 130 of penal law. Now, this is where I'm saying, see if you think this is the playbook. If it reminds you of the Fat Joe case. Unable to remedy the multitude of pleading defects, plaintiff attempts to rehabilitate his complaint by improperly raising matters not addressed by Mr. Combs and by submitting inadmissible extrinsic evidence, including unrelated criminal convictions and immaterial, scandalous, and prejudicial allegations about purported decades-old conduct that has all been adjudicated or otherwise concluded, with a footnote that says, for example, the opposition argues that information and belief allegations are permissible in a complaint. As Mr. Combs never addressed such allegations in the moving brief, it is perplexing that such an argument is made by the plaintiff. For the reasons in the moving brief and those below, the complaint should be dismissed or alternatively stayed, and the improper allegation should be disregarded and struck. And then we've got one more bit. We needed that for context here, but we're getting there. They say that, look, stripped of its immaterial, scandalous, extraneous, and stale allegations, the opposition fails to rebut that the complaint fails to state a claim as a matter of law. You cannot rehabilitate the initial complaint, and therefore it needs to be dismissed. The claimed incident, oh, okay, there we go. Never mind, I was wondering why I didn't highlight the other page. I guess I just made a mistake with the tweet. So here it is highlighted. So there we go, another, that was the Kirk Burroughs v. Combs case. And I think we're getting to mid-May. We might be back to the Fat Joe docket at this point. All right, because this is where I tweeted about the failure to pay sanctions, the order to show cause. I found this quote from a pleading from Tyrone Blackburn. Some filing he submitted in some case, April 24th, 2025. It's in the academics case. This is a quote from Tyrone Blackburn, and he bolded it. He said, "The rules must mean something. This court should not allow defendant, who would be academics in this case, to frustrate discovery, waste judicial resources, and obstruct plaintiff's path to justice. The relief requested is not punitive. It's necessary to restore the balance of fairness and uphold the court's authority." So in 2025, Tyrone Blackburn was saying the rules must mean something. Academics is not complying with discovery. You've got to enforce something. Deter this type of behavior, enforce something. Now, fast forward, we just learned that because Tyrone Blackburn, they weren't complying with discovery, Abashi's complaint was dismissed, again, without prejudice. So, a little bit of interesting irony there. What else do we got? May 15th, one day later, we are back on, this is where we get the omnibus motions to dismiss filed by everybody except Roc Nation. And let's see. Lauren Conlon discussed the sanctions hearing a little bit. So I've got to update the description. I'll drop a link to her article. I'll have to update the description and drop a link there. But she talked about the sanctions hearing a little bit. And then all right, here we go. Here we go. We are finally caught back up and going back to the Fat Joe docket. So if you guys remember, a few months ago, I'm like, I don't know how to cover this stuff in a stream because there's always so much going on. There's always like 10 different moving parts. There's so many cases, if you will. And then within one case, there's a lot of chaos. So the best way it seems to do it is if you guys ever want to go and backtrack anything, for probably since like September of last year, anytime I have an update on not just the Fat Joe case, but anything Tyrone Blackburn related, I'm trying to quote the previous update within it. So the most recent update will quote to the previous one, and you could just like continue clicking through the quoted tweets over on X and go down the rabbit hole, because otherwise it just gets too complicated to try to follow. So that's my Band-Aid solution there. And then back over here, we have Tyrone Blackburn's response to the order to show cause. So let's get into that. Let me close some tabs. I've got like 18 open. All right, so this is Tyrone Blackburn responding to the order to show cause. So, dear Judge Rochon, defendants Tyrone Blackburn and Tyrone Blackburn Law Firm. So notice he's not responding on behalf of Terrance Dixon. Even though Terrance Dixon's his client, this request, this opposition, is only on behalf of himself and his law firm. So he's a sole practitioner. So he respectfully submits his response to the court's order to show cause dated May 14th, directing defendants to show cause why they should not be sanctioned for failing to comply with the court's April 24th order. For the reasons set forth below, defendants respectfully submit that 1. They did not receive invoices billed to defendants or payable through defendants' Veritext account, and acted in good faith to assume responsibility for payment once the invoices and amounts were confirmed. 2, they've made a partial payment today. So you have this order to show cause deadline today. You had Fat Joe's team try to reach you on May 11th. They write to the court on May 13th. On May 14th, the judge issues an order and gives you a deadline. And on the deadline, you finally make a partial payment, while you're also arguing you can't make a payment because it's not invoiced correctly, which I think, in my opinion, this was a BS excuse. And they commit to paying all amounts the court determines to be owed. And then 3, to the extent the court reaches the amount to be reimbursed, the court should clarify or reduce the reimbursable amount to exclude avoidable vendor costs plaintiff failed to mitigate. So they're asking here, I know we're late, and I know I'm only responding very last minute at this order to show cause, but I also want to argue with the court to reconsider the ruling for that $2,500 and change dollars that you ordered us to pay. You should reduce it because the plaintiffs should have mitigated and not had to pay for this in the first place. So then they go through this invoice thing, and they're really griping about it not being invoiced properly, but it doesn't matter because they have the information on where to wire the money. And they know the invoice amount. The invoice amount is correct. To me, this is just a complete bullshit excuse. Then they have defendants have acted in good faith to comply. So they're saying, we've tried. Upon confirming the invoices, amounts, and billing configuration through ECF, that's the docket number 192, defendants promptly took steps to effectuate payment. The invoices, however, were originally billed to the account of Reed Smith LLP, plaintiff's counsel, not to defendant's account. Defendants were therefore unable to pay directly on those invoices as originally billed. Beginning on May 14th, 2026, the same day this court issued the order to show cause, defendants contacted Veritex Client Services to request a transfer of invoices to defendant's own account. So do you guys see the problem with this? If you have a 10-day deadline to pay something, and the deadline is before May 14th, because on May 13th, we're already getting the filing, the letter from Fat Joe's team that they're late. They haven't made a single payment. And not only that, but Fat Joe's team tries to initiate communication on May 11th. They don't answer. Shouldn't you have been trying to sort out any purported invoice issues before the deadline? This is a court-ordered deadline. This isn't just like a handshake, like, thank you for buying my McDouble. I'll cash up you $5. Oh, I forgot. Let me do that now. This is a court-ordered payment. And you have 10 days to do it. And then opposing counsel's reminding you that you still haven't made a payment. Are you going to make good on that? And yet you're waiting till past the deadline when the court issues another order, ordering you to show cause. That's when you finally take the initiative to act like you're calling Veritex. This seems like you're trying to retroactively manufacture an excuse, if you ask me. So they attach the email correspondence, and again, this date range is all after the deadline. Despite multiple follow-up communications on May 14th, 15th, and 18th, all after the deadline, the transfer was not completed until May 19th. On May 20th, defendants immediately made a payment of $368 towards invoice number, and they give the number, and they attach the transcript receipt, the transaction receipt. They say this record demonstrates that defendants' delayed compliance was not willful, but rather the product of a logistical impediment in Veritex billing process entirely outside defendants' control. Oh, man. Then they say, alternatively, the court should clarify or reduce the reimbursable amount based on plaintiff's failure to mitigate avoidable vendor costs. So, they're going to argue here that because it is true that counsel should, be reasonable when there's issues, try to limit and mitigate any exposure to wasted costs. And that's kind of like a duty you should have to your own clients. What's the excuse here? Why is Blackburn arguing this should apply here? They say the February 6, 2026 deposition, which was $903 and $588, plaintiff had more than 48 hours advance notice that defendants would not appear. On February 3rd, Defendant's counsel notified plaintiff's counsel by email that he'd undergone a medical procedure that same day and was unable to attend the scheduled depositions. Notice what we leave out here. In that correspondence, the February 3rd correspondence, Blackburn represented that he would notify the court because it was a court-ordered deposition date. This wasn't just, you set depositions, everyone tries to make it work, and if you don't, then you bring the judge in. The judge was already involved. The judge ordered these dates. The judge had Tyrone Blackburn agree to these dates on the record and then issued her order confirming those dates. And then Tyrone Blackburn in this February 3rd email says, I will notify the court. But we leave that out of this information. On February 5th, the day before the February 6th deposition, defendants they finally tell the court, formally advising that counsel had undergone medical procedures on January 23rd and February 3rd, was prescribed narcotics and antibiotics, and was medically unable to prepare for or attend the depositions. In this filing, they explicitly requested that the court extend the discovery deadline by 2 months and permit the parties to confer and propose new dates. And what they're not specifying here is this request was to expand all discovery because Tyrone Blackburn never scheduled a deposition of Fat Joe, which you would think, if you're the attorney trying to sue, you're representing your client trying to sue somebody, you want to order a deposition for that person so you can get some more information and prepare for your case. They never did that. Oopsie. So they made these requests. They kept trying to reopen the entire discovery window, even though it was foreclosed. The only reason the discovery window was still in place, open, for these additional depositions is because Fat Joe's attorneys had done everything they needed to do to try to get these depositions done. And it was the fault of Terrance Dixon and Tyrone Blackburn why these things could not occur. So there was a very narrow extension of the discovery window just for those 2 depositions, for cause. But here, we're highlighting that we even asked the court to give us more discovery, things that are beyond the bounds of just needing to reschedule this one thing. But then they say plaintiff thus had advance notice from February 3rd and documented court-filed notice on February 5th that defendants maintained they could not medically proceed. Veritex cancellation policy permitted no-cost cancellation of the February 6th deposition by 4 p.m. on February 5th, 2026. So they're saying because we filed something with the court on February 5th with the court, we don't have a timestamp here. Notice that. We don't have a timestamp. Oh, they should have known because we notified the court. Even though the court didn't make an order granting an extension, they should have just on their own gone to reschedule this deposition. That the parties were ordered at this point in time, as of 4 p.m. on February 5th, all parties were still under a court order to sit for that deposition. Tyrone Blackburn is arguing they should have gone and canceled this deposition anyway. Now, what would happen if they had to go to the court and say, Your Honor, we canceled this deposition, but we need to reschedule it. We only canceled it as a courtesy to opposing counsel. Because I feel in my gut that Tyrone Blackburn would have said, we never told them to cancel the court reporter. Like you shouldn't allow them to reschedule a deposition that they canceled. So I don't see why any reasonable attorney on Fat Joe's side in this would want to cancel something that they had to fight over and over to get, when you know that opposing counsel is going to weaponize the cancellation. Even if you do it on a good faith basis as a courtesy to them, there's a good chance they're going to flip it and reverse it and weaponize that against you to say, look, they're playing games. You shouldn't give them another deposition. We shouldn't have to sit for them. But that's where we are. So they're making this argument here that they could have canceled with Veritex by 4 p.m. on February 5th, a deadline that arrived after our filing had been filed with the court. Not a court order giving the extension, but our request. Plaintiff had the ability to cancel at no cost, had full and formal notice of non-attendance on the public docket, had substantial notice that defendants maintained they could not medically proceed, and that court intervention had been requested, and yet made no effort to cancel. And again, there's no court order. The resulting costs of $1,491.50 for the February 6th date were therefore needlessly incurred within the meaning of Jackson Lipscomb, and there are not reasonable costs recoverable. The notice given for the February 6th deposition, filed on the court's docket the day before, citing documented medical procedures and prescribed narcotics, is plainly not the kind of last-minute gamesmanship that justified proceeding without cancellation. Unlike cases involving uncertainty or strategic gamesmanship, I don't know, I feel like there is strategic gamesmanship. It might not be very good strategic gamesmanship, but I feel like there's actually a lot of that in this case. And not from the side that this would have one infer if they didn't know better. They say defendants had placed their medical inability to proceed squarely before plaintiff and the court before the vendor cost became unavoidable. The case for clarification or reduction, they go to the February 9th deposition. The case for clarification or reduction is even more compelling as to the February 9th costs. In addition to all of the foregoing notice, by the morning of February 6, 2026, 3 full days before the February 9th deposition, the court had issued an order scheduling a virtual conference. An order scheduling a virtual conference. Not granting an extension. This was the day he was leaving for the cruise, and they have a virtual conference. And he quotes here, to address the issues raised in my filings. These 2 letters. Fat Joe's letter saying, hey, counsel hasn't notified the court, and they said they would. And then my filing that, I can't do the deposition, court. You should open the whole discovery window again. Expressly including defendant's request to adjourn both depositions and extend discovery. So this February 9th, they're arguing that this February 9th deposition, that even though the hearing wouldn't take place until the 10th, it was already scheduled on the 6th. So they're saying even though it's just a hearing, they should have made the leap. Fat Joe's team should have made the leap and just sua sponte on their own canceled the 9th deposition. As of February 6th, plaintiff had substantial reason to mitigate avoidable vendor costs for the February 9th deposition, and they give through the same thing. This medical notice, the formal court letter requesting adjournment, and Veritex cancellation policy. Under these circumstances, defendants respectfully submit that plaintiff's decision to allow additional vendor costs to accrue was not reasonable because plaintiff had substantial advance notice that defendants could not medically proceed and that court intervention had been requested. There was no meaningful uncertainty that defendants had withdrawn their availability and placed their medical inability to proceed before the court, and no apparent reason to allow avoidable vendor costs to accrue once the court scheduled a February 10th conference to address the disputed deposition schedule. And let's see. He's going to say the commitment. To the extent the court declines to clarify or reduce the order, in whole or in part, defendants are committed to satisfying any amounts the court determines to remain owed. So currently, while he's writing this, he's late. There is no court-given extension like, hey, it's okay that you're late for a little bit while we figure this out. This is all just assumed. And square peg, round hole by Tyrone Blackburn. It's all him making a request. But he's writing as if, everybody knows we're just waiting for the court to clarify these things. It's a good basis. It's happening. No, this is only in his own head, his own request, that he deserves this, he's entitled to this, and he's late because he's waiting for clarification. But then he says, even if you don't change your mind on the amounts, we're committed. Defendants have already paid $368 today. So we probably chose to make the smallest payment so we could weaponize that as, hey, we're good faith, we're making payments while we make the above requests. It's strategic gamesmanship. Due to current financial constraints, defendants respectfully request that the court permit payment of any remaining balance determined to be owed through a short installment schedule. Defendants respectfully propose to pay the remaining balance, if any, in 3 installments, and they give $588 by June 5th, $725 by June 19th, and $903 by June 30th. Defendant makes this request in good faith and not for purposes of delay. Defendants will remit additional partial payments as funds become available. Defendants will continue to make every effort to comply and sincerely regret the delay. And then, let's see. Yeah, they just say, we want the payment schedule and we want the court to clarify or reduce the reimbursable amount. So that was submitted let's see, May 20th. Then they have the the May 18th sanctions hearing. That is for the back and forth cross sanctions motion over the conduct when the depositions actually took place. Oh, Joe Takapina was threatening me. He was getting aggressive in my face, and Takapina, Fat Joe, saying that Tyrone Blackburn was refusing to answer questions. So, let's see. We can release of transcript set for August 19th. So maybe we'll get back together on August 19th and take a look at that. Then they file the transcript notice. Then we have June 1st. We have response to the order to show cause filed by Tyrone Blackburn. Let's see. This is just the order. So I'm not going to buy this because it's pretty much typed up here. But defendant's request to reduce the sanction imposed by the court on April 24th is denied, as the court will not reconsider its ruling imposing sanctions. While the court does not find that defendant's delay in payment is excusable, so they say we don't buy your excuse, but we will permit an installment schedule of payment for sanctions with $588 due by the 5th, $725 by the 19th, and $903 due by June 30th. Defendants shall inform the court that all payments have been made in a status update by July 2nd. If the payments are not timely made, the court will consider further sanctions. So ordered, Judge Rochon. And then we get to Alex Spiro. Alex Spiro. So let's get into that. This is the meat and potatoes here. But, this was the first thing I saw, and I was like, oh, I wanted to go live so bad last night, but I was too tired. And I was also watching Defense Diaries read the state's reply in the Aaron Spencer case. So I was like, I'll just do it in the morning. So here we are. Alex Spiro says, look, take notice, we are asking for sanctions. And we've got 33 pages. And I took a look at this last night just to confirm, like, all right, motion for sanctions, is it going to just be against Terrance Dixon? I suspected not. But because he's the only plaintiff in this, this, unlike the Fat Joe lawsuit, the Fat Joe complaint against Terrance Dixon, Blackburn, whatever, Roc Nation is only a party as a defendant in a case where Terrance Dixon is the sole plaintiff. But I looked at the table of contents, and sure enough, look how many times you can see Blackburn's name. So I'm like, yep, he's going to be involved. So here we go. We've got defendant Roc Nation, LLC, respectfully submits this memorandum of law in support of its motion for sanctions against plaintiff Terrance Dixon and his counsel, pursuant to Rule 11 of the Federal Rules of Civil Procedure, 28 U.S.C. Section 1927, and the court's inherent authority. Roc Nation requests dismissal of plaintiff's claims against it with prejudice and attorney's fees and costs. So, reminder, we skipped the omnibus motion to dismiss filed by all of the other defendants against Terrance Dixon's lawsuit. Roc Nation wanted to file their own, so this is it. The preliminary statement, they say every claim that plaintiff Terrance Dixon and his counsel Tyrone Blackburn have levied against Roc Nation has been baseless. That was true when they filed the original complaint, asserting a time bar racketeer influence in corrupt organizations RICO claim, and a frivolous Trafficking Victims Protection Reauthorization Act, the TVPRA claim, and remains true now. Their decision to drop the headline-grabbing RICO claim in the first amended complaint, that's going to be referred to as FAC. So if we see that, they're talking about the first complaint that had all of the RICO stuff. After 9 months on the docket, dispelled any doubt that the claim was meritless. Their inability to identify a single additional fact that would warrant the assertion of venture participant liability under the TVPRA. This is how this would be the vehicle that Roc Nation purportedly could be roped in under. But they're arguing here that they didn't identify a single fact that would warrant the assertion of such a vehicle. And that confirms that no such facts exist. And the assertion of New York labor law claims under a manufactured joint employer theory, and less than a year after admitting plaintiff is an independent contractor, confirms that plaintiff and Mr. Blackburn knowingly asserted frivolous claims in the first amended complaint in a desperate effort to keep Roc Nation in this lawsuit. The pattern is clear. The first amended complaint and its predecessor were filed for an improper purpose and without an adequate inquiry into the facts or the law. The first amended complaint does not cure the initial Rule 11 violations, it compounds them. As this court recently observed, quote, the warnings and sanctions by the other courts, as well as the CLE courses, did not have an appreciable impact on Blackburn. Gotta love it. They got Rule 11, Section 1927, and the court's inherent authority exists precisely for this type of conduct. The court should impose sanctions, dismiss the First Amendment complaint with prejudice, and award Roc Nation its attorney's fees and costs in defending itself and prosecuting its Rule 11 motions. So, factual background. So, if you haven't followed like the initial complaints, this will give you the basics. So, plaintiff Terrance Dixon was Mr. Cartagena's hypeman, Fat Joe, hypeman, between approximately 2005 and 2020. After 15 years, their working relationship fell apart. 3 years later, in June 2023, plaintiff waged a sustained social media campaign against Mr. Cartagena for 2 years. Mr. Blackburn, this is another section, Mr. Blackburn's pre-filing threats and filing of the complaint. So before Blackburn files the complaint, this is all the mess that was going on. And I'm sure a lot of this is going to cite to some of the counter claims, or not the counter claims, the initial lawsuit, but the related case here filed by Fat Joe. Plaintiff's efforts to tear down Mr. Cartagena publicly and professionally did not end on social media. After attacking Mr. Cartagena for 2 years, plaintiff retained Tyrone Blackburn. On March 23, 2025, Mr. Blackburn sent Mr. Cartagena a letter demanding compensation for purported unpaid wages to plaintiff. Additional demand letters to and conversations with Mr. Cartagena's counsel followed over the course of a month. With each successive communication, Mr. Blackburn ratcheted up the pressure, making increasingly outrageous allegations and identifying new claims over time. Ultimately, he claimed that if Mr. Cartagena did not capitulate to his client's $20 million settlement demand, he would file a lawsuit asserting RICO and TVPRA claims against a wide range of defendants. Now, a lot of this was discussed. We heard some questioning on it, at least. We didn't get so many answers in the deposition of Tyrone Blackburn by Joe Tacopina. There's also been a lot more detail on this in the motions filed by Fat Joe. So we talked about that, I think, a lot in the most recent stream. But during the deposition, Tyrone Blackburn was like, we weren't doing all that. We were just trying to have a friendly conversation. And Tacopina's like, for what? You wanted like an apology? You're seriously sitting here and saying that's all you wanted? So that's a time that's worth going back and watching if you missed it. Rather than cede to plaintiff's demands, Fat Joe, Mr. Cartagena, filed a lawsuit against him and Mr. Blackburn for defamation on April 29th, 2025. Now, they're just calling this defamation. It did include extortion as a claim. That claim has been dismissed, but the information relating to extortion is still admissible, especially in the discovery stage, because it underlies the defamation claims. So extortion as a cause of action is no longer part of the Fat Joe suit against Terrance Dixon and Tyrone Blackburn, but as, material context to the defamation claim, which still stands, extortion is still in play. Mr. Blackburn and plaintiff followed through on their threats on June 19th, 2025, when they filed the initial complaint, which asserted claims under RICO, the TVPRA, and several state laws against Mr. Cartagena, and numerous defendants, including Roc Nation. And precisely what Mr. Blackburn intended to happen, happened. The outrageous and scandalous allegations garnered significant media attention. Numerous media outlets reported on the lawsuit, including the Los Angeles Times, USA Today, NBC News, Variety, Billboard, All Hip Hop, and others. Each of them described it explosive allegations and called it a bombshell racketeering case. Yeah, I think it was a dud. They have a footnote here that says, see Rachel Scharf's article, Fat Joe lawsuit, Roc Nation wants out of case, says it has nothing to do with any of this. Published in Billboard on June 23rd, 2025. Describing explosive new lawsuit, framed as a racketeering enterprise abetted by Roc Nation. They say, see also Nolan Strong, Fat Joe hit with $20 million civil RICO lawsuit alleging money laundering, recording sex acts, PPP scam. And this is published in All Hip Hop on June 19th. We've got Lawsuit targets Roc Nation, which Dixon says played a role in concealing his work and facilitating the alleged misconduct. Then we've got Fisher Jack writing for YourWeb. Fat Joe hit with explosive $20 million lawsuit from former hypeman. And in the article, it says Roc Nation named in the lawsuit for alleged complicity for helping to conceal Dixon's rights and pressuring him to stay silent and enabling the culture of abuse. We've got, oh, that's a different footnote. All right, so we'll come back to the second footnote. Mr. Blackburn went on his own media tour, publicly professing to having, quote, 3 additional pages of predicated acts, which we are itching to disclose if the defendants call our bluff. Now, notably, before we get to this footnote here, notably, in the Fat Joe case, Fat Joe's attorneys have been calling that bluff. I think Alex Spiro did too. I think some of the other defendants against Terrance Dixon's complaint have been calling that bluff. And yet, for whatever reason, none of this discovery is being turned over anyway. So you have Mr. Blackburn going on these media tours, telling the media, as litigation's going on, we have all of these things that we're willing to bring in. We'll disclose it as part of this litigation. Telling the media this, waving it around, fueling these salacious headlines. And yet we don't get discovery. We have non-compliance with discovery. That's not appropriate behavior for an attorney involved in, and really is a defendant in one of these cases now, but going on a media tour and talking about information that ultimately does not even become part of the case. So there's a footnote here that says it's Anna Kaufman. Fat Joe faces explosive sex trafficking lawsuit from former hypeman. Last updated June 20th, 2025. And then they link to the article there. So next we have the Blackburn email and Roc Nation's first sanctions motion. And this, I just love this. This is just delicious. So after saying, we want someone to call our bluff, Spiro says Roc Nation did just that. Before the ink on the complaint even dried, it moved for dismissal. And he did. Like Alex Spiro ran in there like Michael Sprinkle. Mr. Blackburn then sent an unsolicited email to counsel within hours of Roc Nation's filing, 2 business days after the filing of the complaint, and admitted that neither he nor his client believed Roc Nation had any role to play in the alleged misconduct contained in the complaint. Indeed, Mr. Blackburn expressed that, 1, he and his client, this is a quote, think it is evident from the evidence that Roc Nation may have been defrauded by Mr. Cartagena. 2, he was certain, in quotes, Roc Nation may have been caught off guard by Mr. Cartagena's lack of transparency and honesty. And 3, he was sure that Roc Nation did not and would not have approved of Mr. Cartagena sending threats via Instagram. Now, each of these statements is a concession that goes against what's required for the stated claims you just filed against Roc Nation. But okay, this is email correspondence. So, and he filed this previously, back then when he filed that initial motion as exhibits. In light of these claim undermining admissions, Roc Nation served the notice of motion for sanctions on Mr. Blackburn, requesting voluntary dismissal of the claims against Roc Nation. But instead of withdrawing them, he doubled down, opposing Roc Nation's motion to dismiss and insisting the claims had merit. On July 22nd, 2025, Roc Nation moved for sanctions, which Roc Nation incorporates here by reference. Mr. Blackburn opposed that motion on August 8th, 2025, proclaiming to have conducted an extensive and substantial pre-filing inquiry into both the facts and law underlying the client's RICO and TVPRA claims. And now this is great because these claims are now dropped. This is crazy. So back in August of 2025, Blackburn is doubling down, saying, no, Alex Spiro, no, Roc Nation. We've thoroughly investigated. So screw your request for us to dismiss this as frivolous or not having a way to support the claims, not even stating a claim correctly. We've extensively investigated this, and there are viable RICO and TVPR claims. Well, then why are they dropped? They say, but unable to defend the admissions in the Blackburn email, let alone square them with the supposed viability of his client's claims, Mr. Blackburn ignored it completely. The first amended complaint and Roc Nation's current sanctions motion. On March 12th, 2026, over a month after he missed his deadline to oppose the remaining defendant's motion to dismiss, plaintiff belatedly sought leave to amend the complaint to cure alleged pleading deficiencies with his RICO and TVPRA claims. Plaintiff asserted that the first amended complaint would respond directly to the issues raised in defendant's motions. 2, will add targeted factual detail drawn from evidence already in plaintiff's possession for the purpose of substantiating his claim of venture participation liability under the TVPRA and clarifying the structure and operation of the alleged RICO enterprise. And 3, elucidate this claim for equitable tolling of the statute of limitations, why he was late. And, for these claims that you're bringing forward, I'm assuming the idea that I don't know offhand the statute of limitations under these windows, but maybe just clarifying like certain acts being alleged. Do they actually fall under these things and thus get the umbrella of that extended statute of limitations? So he said that he would clarify. And that was a big part of a lot of the defendants, their motions to dismiss were like, we don't have anything to do with this. This isn't true. And even if it were true, it happened like 15 years ago outside the window. The court granted leave to amend on March 18, 2026, noting plaintiff's inexplicable 9-month delay in seeking leave and warning plaintiff that if the amended complaint did not resolve the issues identified in the defendant's motion to dismiss, further amendment would not be permitted. On March 26, 2026, plaintiff filed the first amended complaint, entirely reframing this case. That pleading abandoned the RICO claim, without warning or an explanation for this retreat, reasserted the thinly pleaded TVPRA claim, and raised 5 new New York labor law-based claims that plaintiff never sought leave to plead. And this is problematic. This is the type of warning where you're already on thin ice. Like, you're inexplicably asking for leave to amend something that you ignored for 9 months. And because you failed to timely respond to the defense motion to dismiss, we're going to grant you this leave to amend, but one time. Because we're taking at face value that you're going to do these 3 things that you represented that you were going to do as you motioned for leave to amend your complaint. So based on your representations, even though we don't have an excuse for this 9-month delay, we're going to grant you this one opportunity and that's it. And then you don't do these things that you used as representations when you requested this leave to amend. So I don't know. I think that alone just puts a lot of strength here. And I think the judges have given so much grace to Tyrone Blackburn. But I think that this is the type of thing that would push that grace over the line. And this is it. But we'll see. So anyway, they specify that pleading abandoned the RICO claim without warning or an explanation for this retreat, and then reasserted the thinly pleaded TVPRA claim and raised 5 new labor law-based claims that plaintiff never sought leave to plead. So we don't do what we say. We don't cure the things. We actually just abandon them, and then we try to add 5 new things. To lend credence to his belated assertion of these New York labor law-related claims, plaintiff alleged that he sent a pre-litigation demand letter to the defendants in March 2025, asserting his rights under the New York labor law and demanding payment of unpaid wages and statutory wages. But that's untrue. For starters, Mr. Blackburn sent that letter to Mr. Cartagena, not Roc Nation or any other defendant. And remember, this is before Fat Joe even filed his lawsuit. So here we're having Spiro on behalf of Roc Nation and also saying for any other defendant, we didn't get those letters. Moreover, the letter did not mention the New York labor law whatsoever, let alone assert any purported rights under that statute. It alleged, contrary to the claims in the first amended complaint, that plaintiff was an independent contractor, and it asserted purported claims under New York's Freelance Isn't Free Act. The March 2025 pre-litigation demand letter cannot be reconciled with the first amended complaint. It shows that plaintiff has no legal or factual basis to seek relief under the New York labor law. Roc Nation thus served a second notice of motion for sanctions on Mr. Blackburn on May 5, 2026, requesting withdrawal of the first amended complaint's claims. Neither plaintiff nor Mr. Blackburn has sought to withdraw the first amended complaint within Rule 11's 21-day safe harbor period. Where did I? May 5th. do we have that as an exhibit anywhere? Yeah, I don't see. Yeah, so I'm surprised they didn't attach these as exhibits, but taking it at face value, they're letting Mr. Blackburn know that, look, we're going to file this motion for sanctions. We're letting you know twice. Because what you're claiming here, you're not following the proper procedure under Rule 11, and you have 21 days. And basically, if we think you don't have a good faith basis to do something, we can discuss that with you. You have the opportunity to withdraw this within that 21-day period. It's water under the bridge. But you didn't do that. You let it stand. So we've got Mr. Blackburn's history of vexatious litigation conduct. The court is now aware of Mr. Blackburn's tarnished history of litigation tactics and unethical behavior. It recently provided a lengthy historic recitation of that very misconduct to serve as a public admonition aimed to deter future misconduct, observing that, quote, the warnings and sanctions by other courts, as well as the continuing legal education courses, did not have an appreciable impact on Mr. Blackburn. Roc Nation will not belabor that history, but several of the cases underlying that recitation parallel Mr. Blackburn's misconduct here and underscore why sanctions are warranted. First, Mr. Blackburn has already been referred to the grievance committee once for his pattern of improperly filing cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly. And that's in the Zunzorowski case in Southern District of New York. In Zunzorowski, he even admitted that he'd filed the case in federal court to make the press more likely to pick up on it, a tactic he replicated in this case. Second, Mr. Blackburn has a documented pattern of asserting blockbuster claims laden with sordid allegations against high-profile individuals and companies to leverage media attention in pursuit of a quick payday. For example, in Jones v. Combs, he brought TVPRA and RICO claims against Sean Combs and included the record label UMG, Universal Music Group, as a defendant on the basis that it had a licensing agreement with Mr. Combs, a theory reminiscent of his RICO and TVPRA claims against Roc Nation. When faced with sanctions, Mr. Blackburn voluntarily dismissed as to UMG, attesting he had concluded that there is no legal basis for the claims and allegations that were made against the UMG defendants. The Honorable J. Paul Otkin also issued a warning that Mr. Blackburn apparently has not heeded. I love that aside. That he apparently hasn't listened to. That he would be subject to future sanctions if he continued to submit filings replete with inaccurate statements of law, conclusory accusations, and inappropriate ad hominem attacks, and irrelevant insults, misstatements, and exaggerations. Finally, in Jakes v. Youngblood, a case with a history strikingly similar to this one, Mr. Blackburn's clients waged a social media campaign alleging sexual abuse by a respected clergyman and then dispatched Mr. Blackburn to demand $6 million from Bishop Jakes, or else he would sue for unspecified, non-existent tort claims. And this is coming from the plaintiff's opposition to defendant's motion to dismiss in Jakes v. Youngblood over in Western District of Pennsylvania Federal Court. Mr. Blackburn's playbook is now clear. When extortionate pre-litigation demands fail, lean on outrageous and salacious RICO and TVPRA claims, capture the headlines, and hope that someone with deep pockets buckles. Prior warnings that this conduct will not be tolerated have not been sufficient. All right, and so legal standards. So let's learn a little bit more about Rule 11. This court is empowered to issue sanctions under Rule 11, 28 U.S.C. 1927, and its inherent authority. These bases can all be raised in the same motion, and they cite the case U.S. v. Teamsters. And they've got a footnote. Unless otherwise indicated, this memorandum omits from quotations and citations all internal quotation marks, alterations, footnotes, and citations. All right, so Rule 11, you guys. And this is making me think of, there's been some motion finally in, if you guys remember, Alex Spiro also represented Jay-Z in some of his proceedings in relation to Jane Doe, one of the Jane Does that was suing Diddy and a bunch of John Does. Jay-Z was one of the John Does. Alex Spiro represented Jay-Z in the Southern District of New York case. Once Jay-Z was identified, Alex Spiro filed Rule 11 motions against, or wanted to, against Tony Busby. I almost called him Tyrone. Tony Busby. And Tony Busby didn't get proper admission to practice before the court, and Alex Spiro was like, look, he's doing that intentionally to avoid being under the court's jurisdiction so he can avoid being sanctioned for certain things like Rule 11 misconduct. And that case has sprawled out. There's a California action. There was an Alabama action that just got transferred back to the Southern District of New York. And very recently, Jay-Z has filed a motion giving some additional context where he lays out the timeline and makes the formal accusation that David Fortney, Tony Busby, fabricated claims that Jay-Z's people were threatening Jane Doe's life as an excuse, as a pretext to get Jane Doe to dismiss the Southern District New York case right on the eve of Tony Busby's deadline to show cause for, did you get proper admission? Why not? And he hadn't done so. So while I'm seeing this, and we're talking about Alex Spiro, I'm thinking of that. And if you're interested in that, let me know, because there has been a new meaty filing in that case for the first time in many, many months. So, and that's going to be a hot mess to follow. Camille Vasquez, Sam Manes, they've all filed for pro hoc vice admission on behalf of Tony Busby and his law firm in the Southern District of New York. So those are big powerhouse attorneys on both sides. So if you're interested in that, we can talk about that on another stream. But if you missed that, that has finally had an update, that case. But back to Rule 11 and how it relates to what Roc Nation, Alex Spiro are arguing here against Tyrone Blackburn. The central purpose of Rule 11 is to deter baseless filings. And it's not just to protect someone from being wrongly accused and having to be drained by litigation. It also keeps the court efficient. Like, the court doesn't want to deal with hot mess garbage either. Unfortunately, it seems to have to deal with a lot. But Rule 11b thus requires any attorney presenting a pleading, written motion, or other paper to the court to certify that, to the best of their knowledge, information, and belief, formed after a reasonable inquiry. The paper, 1, is not being presented for any improper purpose, such as to harass. 2, the claims, defenses, and other legal contentions are warranted by existing law. And 3, the factual contentions have evidentiary support, or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Now, we've got a lot of problems here because Tyrone Blackburn didn't schedule depositions, so you're probably not making a good faith effort to do further investigation or discovery if you're not even setting depositions with critical people like Fat Joe. The other part here, that the claims or defenses or legal contentions are warranted by existing law. Well, if you're not properly stating the claim or providing facts that would support such claims, you have a problem there, this was a major issue that when Tyrone Blackburn sought leave to amend the complaint was supposed to cure and didn't do so. And then 1 is not being presented for any improper purpose, such as to harass. I've already formed my opinion. I believe that this lawsuit is to harass, and in a way, not just to harass, but to counterbalance what I think is a valid claim of defamation against Dixon and Blackburn, right? Oh, you're suing, so we're going to sue back to bring it down to an even playing field. So that's what I think about that. Then we have, if all the attorney has is his client's assurance that facts exist or do not exist, when a reasonable inquiry would reveal otherwise, he's not satisfied his Rule 11 obligation. Now let's go to 1927. Section 1927 provides that any attorney who so multiplies the proceedings in any case unreasonably and vexatiously may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred because of such conduct. To obtain sanctions, there must be clear evidence that 1, the offending party's claims were entirely meritless, and 2, the party acted for improper purposes. Completely meritless actions give rise to an inference of bad faith. And we have a quote here from Oliveri v. Thompson. Section 1927 sanctions are appropriate where attorneys' actions are so completely without merit as to require the conclusion that they must have been undertaken for some improper purpose. Next, we have the court's inherent power to sanction. A federal court may also exercise its inherent power to sanction a party or an attorney who has acted in bad faith, vexatiously, wantonly, or for oppressive reasons. The imposition of such sanctions serves the dual role of vindicating judicial authority and providing redress for litigants who bear the brunt of a party's bad faith acts. Rule 11 does not displace the inherent power to impose sanctions for bad faith conduct. As with Section 1927, courts may impose sanctions pursuant to their inherent authority where the offending party's claims were entirely meritless and 2, the party acted for improper purposes. Let's see. But the reach of the court's inherent authority to sanction is broader than under Section 1927. The inherent power extends to a full range of litigation abuses and works to fill in the interstices? I don't know how to say things. Left by existing rules and statutes. And then we've got the argument. So Mr. Blackburn and plaintiff's conduct is sanctionable under Rule 11. So Rule 11, failure to do this investigation, failure to do the due diligence, failure to state claims that actually have a basis supported by the statutes, by the law. The original complaint asserted RICO and TVPR claims against Roc Nation that were frivolous on their face. Days after signing that pleading, Mr. Blackburn admitted in writing that Roc Nation did not belong in this case. He then publicly defended those baseless claims, both in the press and in opposition to Roc Nation's motions, while they languished on the docket. Just 2 months ago, on behalf of plaintiff, he filed a first amended complaint that dropped the RICO claim without explanation, failed to cure the TVPR claims deficiencies, and added baseless New York labor law related claims he never sought leave to plead. The First Amendment complaint, however, does not moot the Rule 11 violations of the original pleading, and like its predecessor, it is meritless and brought for an improper purpose. I think dropping gives credence that there was no color to the claim in the first place. You sit for 9 months with no excuse. You ask for leave to amend to fix it, and then you just drop it. Mr. Blackburn and plaintiff violated Rule 11b1 by filing the original complaint for an improper purpose. The original complaint was filed for the improper purpose of garnering media attention in an effort to extract an outsized settlement, a page from Mr. Blackburn's well-worn playbook. The abandonment of the RICO claim in the first amended complaint only confirms that it was baseless from the start. Argument 1, on its face, the original complaint was frivolous. The original complaint asserted RICO and TVPR claims based entirely on Roc Nation's artist management relationship with Mr. Cartagena. That's Fat Joe. From there, plaintiff begged the inference that Roc Nation must have known about and participated in all of Mr. Cartagena's alleged conduct. But that position is so devoid of logic, common sense, and any legal basis that it suggests plaintiff had an ulterior motive in suing Roc Nation. And they cite here Katzman v. Victoria's Secret catalog, quoting, "The total lack of substance of a complaint gives rise to the inference that the action was filed for improper purposes." Indeed, the pre-litigation history reveals that plaintiff did not even consider suing Roc Nation until his efforts to obtain a settlement from Mr. Cartagena failed. In the 2 years before plaintiff retained Mr. Blackburn, he made negative social media posts about Mr. Cartagena, not Roc Nation. Mr. Blackburn sent pre-litigation demand letters to Mr. Cartagena, not Roc Nation. And while he was threatening Mr. Cartagena with an ever-growing lawsuit, he engaged with counsel for Mr. Cartagena, Joe Tacopina, not Roc Nation. That makes sense. Alex Spiro's probably like, I wish he engaged with me. That makes sense because Roc Nation has no direct relationship with plaintiff, nothing to do with his work, and nothing to do with his private wage dispute with Mr. Cartagena. Mr. Blackburn's post-filing statements confirmed the original complaint's improper purpose. Once Roc Nation challenged the complaint, Mr. Blackburn made several admissions that undermined his own client's claims. So they cite back to those emails. In his unsolicited email, he just volunteered to us. Mr. Blackburn conceded, among other things, that he believed it was evident from the evidence that Roc Nation was a victim of Mr. Cartagena. 2, believed that Mr. Cartagena was less than transparent and honest with Roc Nation. 3, was sure Roc Nation would not have approved of the type of conduct plaintiff had alleged, including sending threats via Instagram. He also referenced new violent predicate acts that he assumed Roc Nation knew nothing about. So, but you're supposed to, the allegation is that they're a participant, like a vendor participant. So how do you square that with these email statements? But anyway, these statements cannot be reconciled with plaintiff's allegations that Roc Nation knowingly participated in racketeering and human trafficking and illuminate the Rule 11 violation. And this here we have China AI Capital Limited, granting Rule 11 sanctions against plaintiff and its counsel where neither could have reasonably believed that the allegations in the complaint had any evidentiary support. Yeah, and so you're getting quotes like, "You're sure Roc Nation wouldn't have approved. It's evident from the evidence that Roc Nation was a victim, not a perpetrator. And you believe that Mr. Cartagena was less than transparent and honest," meaning you didn't know, you didn't have knowledge. So, yeah, these admissions in these emails demolish the idea that you would have reasonably believed there's evidentiary support for what you're claiming against Roc Nation. Nevertheless, plaintiff opposed Roc Nation's motion to dismiss, insisting his RICO claim was adequately pleaded, and his headline-grabbing RICO and TVPRA allegations against Roc Nation then lingered in the press for 9 months before he sought leave to amend, increasing Roc Nation's harm. And from Gong v. Sarnoff, we have, "The longer a frivolous and harassing complaint remains outstanding, the greater the harm." So again, it sits there for the 9 months. And I really think my personal opinion is bringing Roc Nation into it. The idea that Roc Nation, if you go on social media, and I think a lot of Tyrone Blackburn's litigation is geared with social media reactions in mind, virality, putting pictures in certain pleadings, salacious allegations, even going out and doing interviews. I think he's very in tune with and wants that type of social media attention when he files certain cases. So I think putting Roc Nation in there was a strategic play to pick up on some of the ongoing Roc Nation discourse on platforms like X, where you have like Meg Thee Stallion, you have Nicki Minaj, you've got all of this commentary about, Roc Nation, nobody can mess with them, we need to bring them down. And because some people, for other grievances that they may have, valid or not, with Roc Nation, they might automatically amplify, adopt, and believe the claims that Tyrone Blackburn is filing on behalf of Terrance Dixon now that Roc Nation's name is looped in there, right? And that's why sometimes, like, generally speaking, just because somebody or some company does one thing wrong, you've got to take in every situation in its own stance, right? Because even if there is support for Roc Nation having a misdeed or misdoing in another case, I really think the playbook here was just to play on that without actually having any evidentiary support that Roc Nation engaged in RICO and TVPRA actions involving Terrance Dixon. But it went viral. It went viral because I think Roc Nation was put in the headline. So then they've got abandoning the RICO claims confirms Rule 11b1 violations. Mr. Blackburn and plaintiff cannot sidestep their initial Rule 11 violation of asserting a baseless RICO claim against Roc Nation by abandoning it in the amended pleading. If anything, the abandonment of that claim, but not the entire case, is further evidence of their misconduct. A baseless filing puts the machinery of justice in motion, burdening courts and individuals alike with needless expense and delay. As such, a Rule 11 violation is complete upon the presentation of an offensive pleading to the court. They cite here Australia, INRAE, Australia, and New Zealand Banking Group. That says, let's see, and Ultra Temp Corp v. Advanced Vacuum Systems. Sounds interesting. Rule 11 violation attendant to filing of the original complaint is not cured by the filing of an amended complaint. So then we've also got from Gong, which was cited earlier, sanctions motion was not mooted by plaintiff's filing of the amended complaint. That makes sense. If a litigant could purge his violation of Rule 11 merely by filing an amended complaint or voluntarily dismissing a claim, he would lose all incentive to stop, think, and investigate more carefully before serving and filing papers. So we can't just file whatever we want and shield ourselves from Rule 11 violations by amending it after the damage has been done. Now, this is from Cooter and Gell, and Gaffney v. Muhammad Ali enters, saying that Rule 15a amendment eliminating a complaint is the same as the Rule 41a voluntary dismissal of the claim. They say INRAE Australia is instructive. It's not just an opinion, it's not just opining, this is what you must do. There, an investor filed a complaint on behalf of a putative class of shareholders who purchased securities based on defendants' alleged misrepresentations. The plaintiffs asserted that those misrepresentations, which were the linchpin of their fraud claims, were contained in a series of internal emails from March of 2007. Shortly thereafter, the plaintiffs filed an amended complaint, omitting the allegations in paragraph 25 without explanation. After filing a motion to dismiss, the defendants sought sanctions, arguing that the inclusion of paragraph 25 violated Rule 11b. So this accusation that this is from a series of internal emails, they take that out. And they say that this is a violation of Rule 11b3. Why? Because maybe they didn't look at these emails. Why were you making representations about these emails if you didn't look at them? Therefore, the plaintiff's counsel explained that they had misread a news article that discussed the purported emails, and upon determining the allegations in the article were erroneous, there you go, omitted paragraph 25 in the amended complaint. The plaintiffs argued that the mistake was inadvertent, not intentional, and that the amended complaint effectively cured the error by superseding the original pleading, so sanctions were not warranted. The court disagreed. In imposing sanctions, it reiterated that a Rule 11 violation is complete upon the presentation of an offensive pleading to the court, irrespective of the signer's subjective intent. So if you're signing off on this pleading, and you're making the representation that, hey, these fraudulent representations were included in these internal emails sent in March of 2007, that is your representation. It is no longer, upon information and belief, we saw this news article talk about it, and we actually want to do some discovery here. So they say, nope, that's not okay. Plaintiff and Mr. Blackburn's conduct is far worse. Despite their insistence that the RICO claim was properly pleaded and two representations to the court that a First Amendment complaint would correct any of its deficiencies, the First Amendment complaint abandons it entirely. The logical inference is that the claim was baseless from the start. Plaintiff and Mr. Blackburn knew it, and they asserted it anyway. Had they believed the claim was viable, they would have lived up to their representation that an amendment would clarify the structure and operation of the alleged RICO enterprise by more precisely describing the association in fact enterprise, the roles played by each defendant, and the manner in which the enterprise functioned as a coordinated organization over time. And they would have included additional allegations supporting equitable tolling. They did not do so because they're unable to. That the claim they dropped was for civil RICO only compounds the seriousness of the violation. RICO is the litigation equivalent of a thermonuclear device whose commencement has an almost inevitable stigmatizing effect on those named as defendants. And this is a quote. Where is this from? From LCS Group v. Shire. I wonder what happened in that case. So they say the commencement of such a claim of RICO litigation has an almost inevitable stigmatizing effect on those named as defendants, making Rule 11 particularly significant in this context. This is a great case to cite. So not only do we have this other case law that says Rule 11 exists to deter bad behavior at the time a representation is made, at the time a lawsuit is filed with the court. Doesn't matter if you have the subjective belief because you read something in a news article. That's already great case law to have in your pocket for filing a motion like this. But now you have this case that says when somebody's alleging RICO, this is exactly why Rule 11 makes it very significant. Rule 11 is very significant in a particular circumstance where somebody is alleging a civil RICO because it's so stigmatizing. And then you apply it to the context of this case where the first complaint sat for 9 months after there was oppositions filed, motions to dismiss filed by the defendants. 9 months of silence. We don't have an opposition to the motions to dismiss filed by the defendants, by the plaintiff. So that bell was just allowed to sit there rung without any withdrawal, without any correction. And you have that huge swath of headlines talking about Fat Joe, Roc Nation named in RICO, and alleging all these weird sex acts. Just sitting out there. Definitely hard to say that wouldn't be stigmatizing to the defendants. Plaintiff and Mr. Blackburn should not be permitted to escape the consequences of their initial Rule 11 violation by quietly dropping his RICO claim. Mr. Blackburn's pre-litigation behavior and his concessions. Within days of signing the complaint as an officer of the court, so he has a duty of candor, that Roc Nation is not a proper party to this action, coupled with the abandonment on the RICO claim, bring the baselessness of the complaint into sharp focus. We have here the Gong case again. A court may infer an improper purpose if, in light of plaintiff's conduct during and outside of litigation, a complaint is so baseless as to suggest that there is ulterior motive behind the lawsuit. Sanctions are appropriate for this Rule 11 violation, for this initial Rule 11 violation. In Byrne v. Nassat, we have affirming sanctions. This is from the 11th Circuit. Affirming sanctions under Rule 11, Section 1927, and the court's inherent authority, all three, where a plaintiff expanded the scope of his litigation from a garden variety medical malpractice claim into a suit including RICO and other baseless claims, demonstrating she had filed a frivolous lawsuit in bad faith for the purpose of extorting a settlement from the defendants. They said it was abrogated on other grounds by Bridge v. Phoenix Bond and Indemnity Company, maybe? But still saying that sanctions are necessary to forestall consistently vexatious litigation tactics, where defects in the filings and underlying weakness of the substantive claims was reflective of the attorney's larger pattern of litigation. I mean, this seems on point a little bit if you ask me. It seems like it's applicable. We're not dealing with medical malpractice, but aside from that, we've got plaintiff and Mr. Blackburn violated Rule 11b1 by filing the first amended complaint. So now we're going to move on to the amended complaint. The first amended complaint proves that this lawsuit was originally filed and is now being maintained for an improper purpose. First, we have plaintiff's TVPRA claims remain frivolous. Plaintiff's failure to remedy the infirmities underlying his TVPRA claim in the first amended complaint amount to Rule 11b1 violation. Where an offending party fails to correct a pleading whose defects have been identified to him, the offending party is not entitled to relief from a Rule 11 sanction. That's from that Gong case again. That's heavily cited here. The damage has been done and remains. Gong is on point. I want to ring one. There, the original complaint alleged the defendants violated the Foreign Agents Registration Act, the FARA, and conspired to and did violate the plaintiff's constitutional rights. Under pressure of a motion to dismiss, the plaintiff amended the complaint but did not add any factual allegations. Instead, he merely leveled the same allegations that moving defendants participated in civil rights violations and a violation of FARA. The defendants sought sanctions, arguing the claims were legally and factually frivolous and brought for an improper purpose. The court had no difficulty finding that the pleadings violated Rule 11b1 because it contained no non-conclusory allegations that either moving defendant was present at the scene when the offending conduct occurred or that the offenders were acting at the direction of the moving defendants. The court also cited plaintiff's history of lawsuits, which removed any doubt of the harassing purpose of the lawsuit. Ultimately, the court reasoned that the amended complaint's very filing and its failure to address the deficiencies of the complaint compounded the claimed injury to moving defendants. That's precisely the case here. The original complaint asserted that Mr. Cartagena controlled and exploited him, and, as Mr. Cartagena's management company, Roc Nation knew of and participated in a TVPRA venture, allegedly giving rise to venture participant liability against it. But as Roc Nation has demonstrated across two motions to dismiss, there's no basis to infer that Roc Nation knew of any purported TVPRA violations, 2, participated in a TVPRA venture, or 3, received a benefit from a TVPRA venture. Despite being on notice of these defects, because they said they notified Blackburn twice of these defects, plaintiff's first amended complaint rehashes the same allegations from the original complaint. On the fringes, plaintiff asserts a few additional facts. That his purported direct supervisory contact at Roc Nation was Mr. Castillo. He complained to Mr. Castillo at unspecified times about alleged underpayment, mistreatment, and exploitative conditions, and Mr. Castillo had, upon information and belief, actual or constructive authority to relay those complaints to others within Roc Nation. But none of these allegations moves the needle on venture participant liability. The plaintiff asserts no new facts that can. As in Gong, the filing of the FAC and its failure to address the deficiencies of the complaint compounded the injury to Roc Nation. Sanctions are appropriate. Next, we've got plaintiff, so Terrance Dixon and Mr. Blackburn, knowingly asserted baseless New York labor law claims. Plaintiff's belated inclusion of 5 employment-based claims for alleged wage theft, count 1, failure to provide wage notices, count 2, and retaliation, count 5, under the New York labor law, and purported claims for aiding and abetting wage theft, count 9, and joint employer liability, count 10, also violates Rule 11B. For starters, we're just a little appetizer here, a little start. Plaintiff did not seek and was not granted leave to plead New York labor law claims. Plaintiff's application for leave to amend was narrow. As relevant here, Mr. Blackburn represented to the court that the First Amendment complaint would cure the deficiencies in the RICO and TVPRA claims that Roc Nation had already identified in its motion to dismiss. Based on those representations, and only those representations, the court granted leave to amend, but cautioned that further amendment would not be permitted if the first amended complaint did not resolve the deficiencies identified. I think we're in problem territory. Mr. Blackburn's decision to file a first amended complaint that exceeded the scope of the permission granted is itself a violation of Rule 11. And they cite here Dover Steel Company v. Hartford, amended complaint that added defendant, 5 new counts, and new legal theories was grossly different from proposed complaint, violating Rule 11. Notwithstanding plaintiff and his counsel's failure to obtain the court's permission to include these claims, the relevant factual and procedural history exposes their true motive for asserting them: to keep this case alive and Roc Nation in it. As explained in Roc Nation's pending motion to dismiss, these claims suffer from myriad deficiencies and contradict Mr. Blackburn's own pre-litigation admissions that his client is an independent contractor. The timing is telling. Mr. Blackburn never breathed a word about New York labor law claims before he filed the first amended complaint. Not in his pre-litigation demand letters to Mr. Cartagena, not in the original complaint, or in opposition to either of Roc Nation's motions, and not even in his application to the court seeking leave to amend. He raised them for the first time in the first amended complaint. The 11th hour, the 11:59 assertion of the New York labor law claims was not an afterthought. It was a hedge. Fact-intensive claims designed to survive a motion to dismiss long enough to maintain settlement leverage, even as the substantive RICO and TVPR claims collapsed. There is no legitimate dispute that plaintiff and his counsel filed frivolous RICO and TVPR claims and expanded his lawsuit to include equally baseless New York labor law claims against Roc Nation to garner media attention in hopes of extorting a quick settlement. This is a textbook violation of Rule 11b1. Prior warnings to Mr. Blackburn to refrain from engaging in this unethical behavior have not deterred him. Sanctions are appropriate. So they cite here a case called Usherson v. Bandshell Artist Management. Sanctions warranted where counsel maintained the lawsuit without any investigation indicating broad strategy to use the burdens of litigation to extract settlements, even in frivolous or unmeritorious suits. Next, we have Mr. Blackburn violated Rules 11b2 and b3 by failing to conduct a reasonable inquiry into the facts and the law. The first amended complaint, like its predecessor, confirms Mr. Blackburn either failed to investigate the law and the facts with respect to the claims against Roc Nation, or willfully ignored them in violation of Rule 11b2 and b3. First, Mr. Blackburn failed to conduct an adequate pre-filing inquiry into the facts before asserting the TVPR claim and the New York labor law related claims. For the TVPR claim, the FAC, like its predecessor, fails to allege any facts that suggest Roc Nation had knowledge of, participated in, or knowingly profited from any TVPRA venture. These are, required elements of these claims. And yet we're still failing to allege as such, even after asking to cure the deficiencies in the first complaint. What it does allege reflects nothing more than an ordinary course business relationship between Mr. Cartagena and Roc Nation. Mr. Blackburn's own admission, made days after filing the original complaint, says it all and rings true today. It is evident from the evidence Roc Nation may have been defrauded by Fat Joe as well. Plaintiff had an opportunity to replead. He added nothing of substance. The FAC's nearly identical TVPRA allegations confirm that Mr. Blackburn failed to conduct an adequate pre-filing inquiry into the facts before filing the original complaint and has learned nothing new since. Reasserting a meritless claim, notwithstanding its deficiencies, is not a pleading error, it's a knowing violation. Levine is a posit here. There, the second court affirmed the imposition of sanctions on plaintiff's counsel after filing an amended complaint, adding a new defendant even though counsel was aware of deposition testimony, including from the plaintiff, that contradicted any theory of jurisdiction over the defendant. The court determined sanctions were amply warranted, noting counsel's blatant disregard of these facts and holding that the creativity of an attorney may not transcend the facts of a given case. Mr. Blackburn's, quote, creativity, everyone's so creative, in reasserting a factually identical TVPRA claim after a full round of briefing on both a motion to dismiss and a motion for sanctions, and an explicit judicial warning that further amendment would not be permitted if its deficiencies were not cured, likewise transcends the facts. Now I'm going to call everything he does creative. New York labor law-based claims. Plaintiff's New York labor law claims are incoherent. They're incoherent. Mr. Blackburn's own pre-filing demand letter undermines them, and they otherwise rest on self-contradictory allegations. Recovery under the New York labor law is available to employees, not to independent contractors. Plaintiff now alleges that he was an employee and that Roc Nation was his joint employer, but his own counsel concluded otherwise over a year ago. In Mr. Blackburn's March 23, 2025 pre-litigation demand letter to Fat Joe, he described plaintiff as a freelancer and independent contractor who purportedly had viable claims under New York's Freelance Isn't Free Act, a statute that protects independent contractors, not employees. In opposition to Roc Nation's original sanctions motion, Mr. Blackburn professed to conducting a substantial and extensive pre-filing inquiry, one thorough enough. He was purportedly prepared to file suit within 14 days of sending the March 2025 demand letter. I love that call out. That is beautiful. That is beautiful. So you're going to promise you're going to do the substantial and extensive pre-filing inquiry, and just in this narrow time window. And again, this isn't the only case. This was not the only case that Tyrone Blackburn was shuffling and juggling at the time.
So many cases, I don't know. I just can't just, it's like a lot of cases.
But somehow as a sole practitioner, he found the time while juggling all these different cases to make sure he was doing this substantial and extensive pre-filing inquiry. But he's claiming he did. Mr. Blackburn's self-described extensive pre-filing inquiry led him to the conclusion that his client was an independent contractor who has no basis to assert claims under the New York labor law. So it's putting him in a catch-22 here. You're either wrong because you didn't inquire, and if you didn't inquire, you still have a problem. Perhaps that is why he asserted no such claims in the original complaint. The First Amendment complaint's own allegations are consistent with employee status. The First Amendment complaint asserted that he was a freelance touring performer who received a per-show rate on a show-by-show basis, as any independent contractor would. Mr. Blackburn's pivot 9 months after sending the March 2025 letter, while discovery was stayed, suggests that he knew all along that his client was an independent contractor, yet he knowingly asserted baseless New York labor law claims anyway. And they have a case here, Smith v. Winchester versus Westchester County Department of Corrections, which says granting sanctions where it is patently clear that the New York labor law claims have absolutely no chance of success. Then we've got Galasso v. Eisman, Zucker, Klein, and Rutenberg is instructive. There, plaintiff asserted New York labor law and FLSA claims that were meritless on the face of the statute. The New York labor law exempted plaintiff by his professional status as a certified public accountant, and FLSA prohibited plaintiff's claims for vacation and payday. The court-sanctioned counsel explaining there can be no excuse for filing claims that are statutorily barred. The same is true here. But Mr. Blackburn's Rule 11b3 violations did not stop there. There's more. In the First Amendment complaint, Mr. Blackburn asserts that in March of 2025, he sent a pre-litigation demand letter to defendants, plural quotes, which asserted rights under the New York labor law. So we heard about this earlier in this filing, but we're going to get into it here. But this is in quotes. He's saying that in March of 2025, not 2026. So before Fat Joe even filed his lawsuit. And over a month, 2 months before Terrance Dixon files his lawsuit against Fat Joe and all the others. He's claiming that he sent a letter to all of the defendants, plural, asserting New York labor law, specifically. They say that is demonstrably false. That letter was sent to Mr. Cartagena only, and it does not even mention the New York labor law, let alone assert rights under it. That is sanctionable. Yeah, if you have to puff up your representation to make the claim oh, we brought this up earlier. This isn't the first time that we asserted it, but you're lying about the first time you asserted it. That looks like bad faith. So in re Australia, we have erroneous statement of fact can give rise to the imposition of sanctions when the particular allegation is utterly lacking in support. The New York labor law claims are also independently sanctionable because they rest on self-contradictory allegations. As described more fully in Roc Nation's motion to dismiss, almost none of plaintiffs' allegations about Roc Nation are entitled to a presumption of truth because they're either wholly conclusory and made upon information and belief, or flatly contradicted by his allegations against other defendants. For example, the First Amendment complaint asserts that Mr. Cartagena had exclusive control over plaintiffs' professional opportunities and compensation, and exercised sole control over contracts, budgets, tour management, licensing, and credit attribution. That is antithetical to a joint employer theory of liability. Like, what are we doing? Plaintiff had no factual basis to assert the New York labor law claims, but did so anyway, in violation of Rule 11b. And this is a case here, AJ Energy v. Worry Bank, who says self-contradictory assertions in amended complaint clearly lack reasonable evidentiary support in violation of Rule 11b-3. Plain and simple. Colleton v. Kravitz, Swain, and Moore says, awarding Rule 11 sanctions where plaintiff filed an amended complaint consisting of self-contradictory allegations without legal or factual support that contradicted original complaint and appeared concocted to plead around legal defenses raised, including statute of limitations. Next, we have Mr. Blackburn failed to conduct an adequate pre-filing inquiry into the law before asserting the TVPR claim and the New York labor law related claims. The TVPR claims. Plaintiff's TVPR claim has never had a basis in the law, among other reasons, because Roc Nation's receipt of compensation for its ordinary course services to Mr. Cartagena is insufficient as a matter of law for liability. So just because we have a relationship with Fat Joe doesn't mean that some other person can just come in and levy this TVPRA claim against the company that somebody happens to have some compensation from for services that are known to exist, like shows, performances, music. So we've got Mueller v. Deutsche Bank, and I'm not going to pronounce that, holy moly. I can Gillenshaft. That wasn't that bad. I was probably somewhat close on one syllable. Dismissing TVPR claim based on similar allegations of routine financial services. So the labor law claims. Plaintiff's labor law claims, counts 1, 2, and 5, and the purported claims for aiding and abetting a labor law violation, count 9, and joint employer liability, count 10, are also not grounded in the law. Plaintiff's labor law claims are premised on conduct that allegedly occurred prior to 2020. As such, they're barred by the New York labor law's 6-year statute of limitations. Although the First Amendment complaint repackages the equitable tolling allegations from the original complaint, it invokes the continuing violations doctrine, which does not apply to plaintiff's New York labor law claims. Okay, so the equitable tolling is, now that we're adding New York labor law, which now I didn't know earlier in this, it's a 6-year statute of limitations. So now that this First Amendment complaint is coming about in 2026, 6 years after 2020, Blackburn was saying, like, hey, it should still apply because there's tolling, where there's certain reasons that certain blocks of time don't count towards the math adding up to that statute of limitations. And here, Alex Spiro is like, look, this continuing violations doctrine doesn't apply. And this case, Gustafson v. Bell Atlantic Corporation, explaining that each paycheck constitutes a discrete individual wrong and separate cause of action for which suit must be brought within the limitations period, and rejecting same argument. So even if you have something, one transaction that would fall within the statute of limitations, it doesn't apply to revive other instances. I say relatedly, as detailed in Roc Nation's motion to dismiss, the New York labor law does not provide for aider and abettor liability, and joint venture liability is a theory of liability, not a standalone cause of action. The most rudimentary legal... a caveman could do it. The most rudimentary legal research would have confirmed that plaintiffs' New York labor law claims are untimely and cannot be cured by the continuing violations doctrine. It also would have revealed that the aiding and abetting and joint employer liability claims are not cognizable as a matter of law. Mr. Blackburn's failure to conduct even the most basic inquiry into these issues is a violation of Rule 11b-2. They cite Galasso. Counsel is charged with doing a modicum of legal research before bringing a lawsuit. Then we have Gong. Plaintiff's assertion that the court was free to imply that Congress intended to fashion a private right of action only highlights counsel's abject failure to do any research into the basis of his claim before he filed it. Sanctions are appropriate. And I think this might be the last section. Mr. Blackburn and plaintiff's conduct is sanctionable under Section 1927 and the court's inherent authority. Sanctions are also warranted against plaintiff under the court's inherent authority and against Mr. Blackburn under both Section 1927 and the court's inherent authority. So this is a bit of a broadening. They've got Gisson-Danner, which requests for sanctions under Section 1927 and pursuant to the court's inherent authority may be decided in a single inquiry. Mr. Blackburn and plaintiff's conduct amounts to bad faith. Filing a frivolous complaint in June 2025 was plaintiff and Mr. Blackburn's first bad faith act, but it did not stop there. After admitting that they believed it was evident from the evidence that Roc Nation had no involvement in the alleged conduct, they doubled down and opposed Roc Nation's first motion to dismiss, tacking on a frivolous Rule 12F motion, even though a cursory review of that rule would have shown that it does not apply to motion papers. Now, just to put this into context, because so much of this relies on like Fat Joe, this all started with Fat Joe and Terrance Dixon. When we say here that filing a frivolous complaint in June 2025 was Dixon and Blackburn's first bad faith act, again, remember we're speaking, it's Alex Spiro on behalf of Roc Nation. So this is the first time that Roc Nation comes into the picture, right? This is not somebody making a statement that nothing that occurred beforehand was a bad faith act. It just isn't relevant to Roc Nation. Because this is their motion, their filing. We're back here. We have a quote from Brody v. Glob that says, motions, briefs, and other documents outside the pleadings are not subject to Rule 12F. The First Amendment complaint is their latest attempt to vexatiously multiply these proceedings and has forced Roc Nation to prepare a second motion to dismiss, addressing 5 new frivolous claims under the New York labor law and this second sanctions motion. This is textbook bad faith. For example, in Craig v. UMG recordings, the Honorable J. Paul Otkin imposed sanctions under Section 1927 and the court's inherent authority, inferring bad faith based on a motion's obvious lack of merit and counsel's omission of critical details that were fatal to the motion under a basic understanding of the applicable law. Like in Craig, plaintiff and Mr. Blackburn's conduct has improperly forced Roc Nation to expend resources on multiple rounds of motion practice. Noting counsel's conduct forced defendants to prepare papers opposing the motion and required the court to hold a wasteful evidentiary hearing. This court, too, should sanction plaintiff and his counsel under its inherent authority and Mr. Blackburn under Section 1927, particularly now that it is clear they were aware of the meritless nature of plaintiff's claims, yet continued to pursue litigation anyway. We've also got Bayol v. NBC Sports, finding bad faith on this basis. Sanctions are required to deter Mr. Blackburn's pattern of abusing the judicial system. Because, all right, there's got to be somebody out there that's like, so what? Too bad, so sad. Roc Nation has money, good thing. But that's precisely the reason why we're seeing somebody fight this. If you weren't Roc Nation, would you be able to fight this? And even if you have some money, it could entirely drain what money you've built up. So, I'm not a fan of like the too bad the rich have what's coming to them arguments, because the issues at the heart of this, what's being claimed vexatious litigation, these are things that happen to people that cannot afford Alex Spiro to come running in there. Right? So this idea that sanctions are required to deter Mr. Blackburn's pattern of abusing the judicial system, this is the type of thing that would help the next person that does not have the resources that Roc Nation has, should they find themselves similarly situated. Roc Nation does not make this second request for sanctions lightly. Mr. Blackburn's history of unethical conduct and this and other courts' efforts to deter his misconduct obviously have not been sufficient, as this court has recognized. Mr. Blackburn must face the repercussions of his actions, be held accountable, and be deterred from abusing the courts to harass innocent defendants. And this is from the order in Jakes v. Youngblood. Usherson is instructive. There, the Honorable Jesse Furman issued sanctions based on the attorney's misconduct in history. Like Mr. Blackburn, the attorney in Usherson had been repeatedly chastised, warned, ordered to complete ethics courses, fined, and even referred to the grievance committee in scores of cases. Yet, he continually evaded the worst consequences of his action by voluntarily dismissing cases. In light of the scope of his misconduct, overall record, and a case fatally flawed from its inception, Judge Furman imposed sanctions to deter repetition of the misconduct or comparable conduct by others. Mr. Blackburn is precisely the type of similarly situated persons Judge Furman's decision meant to deter. Section 1927 sanctions should be imposed. Then we've got the court should award Roc Nation its costs and attorney's fees and dismiss the First Amendment complaint with prejudice. So remember, this request is really only a request for Roc Nation as a party. The other parties have filed their own omnibus motion to dismiss the First Amendment complaint. And for anything that's like a separate nuance, there were memorandums filed with like Erica Morera had some specific things that went beyond the omnibus motion to dismiss. So she did a memorandum of her own. And again, we can look at those if you guys are interested. But I thought the Roc Nation one was the most interesting because it's my personal opinion that they threw Roc Nation in there to fuel the flames, garner the headlines, and they're just sitting there. They wanted a settlement, and I think, my opinion, because they didn't get a settlement, they sat there for 9 months, failing to oppose any of the previous motions to dismiss the initial complaint, and are just trying to panic, scramble, and hang on for dear life because there's nothing else they can do. So I think this is the most interesting one because I think this really calls that out. Mr. Blackburn admitted Roc Nation respectfully requests terminating sanctions, along with attorney's fees and costs. Mr. Blackburn admitted nearly a year ago that neither he nor his client have a valid basis to include Roc Nation in this litigation. And months before filing the complaint, Mr. Blackburn acknowledged his client's status as an independent contractor, precluding his recently pleaded New York labor law-based claims. Yet, plaintiff and his counsel have continued to needlessly and baselessly subject Roc Nation to intense public scrutiny, embarrassment, and reputational harm. The First Amendment complaint, which somehow adds 5 new claims and almost no new facts, compounded that harm and forced Roc Nation to continue expending resources defending itself against these fabricated claims. The just and fair remedy is dismissal of those claims with prejudice and payment of the attorney's fees and costs Roc Nation has incurred to defend against them. Under the circumstances, this type of severe sanction is appropriate, and they cite again the Katzman v. Victoria's Secret catalog case, awarding attorney's fees and costs where defendants were made to respond to a patently meritless complaint and to suffer unwarranted adverse publicity related to a RICO claim that suffered from a total lack of substance, giving rise to the inference that the action was filed for improper purposes. We've also got Bryant v. Brooklyn Barbecue, affirming district court's award of attorney's fees and costs pursuant to Rule 11, where reasonable inquiry was conducted only after the original complaint had been filed, which pleading was brought for the improper purpose of attracting publicity and to harass the defendants. We've got a footnote here. See also Vista Acquisitions LLC v. West Shore Walden, awarding attorney's fees where no reasonable attorney could have thought plaintiff's claims had any chance to succeed, and plaintiff threatened to file a civil RICO suit only 11 days after an unsuccessful attempt at reaching an out-of-court resolution, which made it clear plaintiff intended only to force defendants to spend money to defend this case and to pressure them to drop their challenges to the city's zoning decision. Now remember, for the purpose of Roc Nation wasn't part of these, it was Fat Joe that was part of the initial conversations. Takapina, Fat Joe, a little bit of Erica Morera, and Tyrone Blackburn and Terrance Dixon. They have these out-of-court attempts to have a friendly conversation, according to Tyrone Blackburn. If you ask anybody else, it seems like they wanted money. It was the money demand. And if you don't pay, we're going to file a civil RICO against you. So while it wasn't Roc Nation that was situated in the initial pre-litigation stages, it's still the same context. Roc Nation is just someone who was brought in once that, we're going to file a civil RICO once that actually came to fruition. So relevant with a different role reversal there. And then we've got, for the reasons stated above, this court should impose sanctions under Rule 11, 1927, or its inherent authority. Should the court conclude that an award of fees and costs is appropriate, Roc Nation respectfully requests that the court direct the parties to confer regarding a briefing schedule for the calculation of that award. Now, respectfully submitted, this was June 1st, Alex Spiro. here from Quinn, Emanuel, Urquhart, and Sullivan. So there we go. I feel like if I refresh the docket, we'll have an update. Something else will have happened in another, either this case or a Tyrone Blackburn adjacent case. Let's see. For good measure, check both dockets. Nothing new there. And on the Cartagena one, still June 1st, but who knows? Maybe by this afternoon we'll have something, because that just seems to be how it's going. So that catches us up. I think we had some other stuff in some other cases that were kind of interesting. But really it's like the same old. Some judge somewhere is yelling at Tyrone Blackburn for not following the rules of the court, or he's late on some payment somewhere else. And I do post those when I see them. I share a lot of what /star finds as well. He's finding a lot of stuff. Maybe she, I don't know. And yeah, so if you want to check that out, I should start linking. I'll put a link in the description to, like, if you go to my Twitter page, X page, and if you just search, like, I always try to put Tyrone Blackburn as the full name in there, but top kind of misses some stuff. Go to latest, and you'll see every tweet in reverse chronological order where I've put his name in. Oh yeah, the criminal case. The criminal case. Okay. That's exactly how we should round this up. So, /star saw this post, and it was posted by Tyrone Blackburn, and it's a statement from Heather Palmore, who seems like they're working on some cases together. Heather Palmore stepped in not just to help with the criminal action, but also stepped in a different case. I think it was Gardner v. Combs, or maybe it was Burroughs. I have to double check. But some case where Tyrone Blackburn wasn't making payments on time. Heather Palmore filed a notice of appearance and was like, look, we're going to take on those payments for these sanctions. We're going to get those payments up to date, and get things back in the green. So Heather Palmore here put together the statement that said, today a Supreme Court justice, and remember, New York, the Supreme Court is the criminal trial court level. The Court of Appeals is like the higher court. But the Supreme Court is not like the state Supreme Court in any other state. It's the trial court. So this equivalent of the trial court in Kings County dismissed the felony indictment against Mr. Blackburn after ruling that the integrity of the grand jury presentment by the Kings County District Attorney's Office was impaired. They put in this quote in bold that says, from day one, Attorney Blackburn has maintained his innocence, and this dismissal today is crucial not only for Attorney Blackburn, but for all members of the community at large that seek fairness and proper due process when facing charges that impact one's life, family, and career. Attorney Blackburn will continue to be a voice for the voiceless and an advocate for women, men, and children that have been sexually assaulted and abused. Signed, Heather Palmore, attorney for Tyrone Blackburn. Now, I was curious because, like, we've been hearing a lot about grand jury presentments going left, things not being done right, and reading that statement, it seemed like it was over and something bad happened. But New York courts aren't that transparent, can't see much. But when I pulled up the docket, the prosecution, it seems like they asked for and the judge granted permission to represent the charges against Tyrone Blackburn to a grand jury. Prosecution is not barred at this time, and there's a status hearing set for July 24th. So you can see here that we have each of the counts is dismissed with leave to represent according to their New York's rules of procedure, 210 section 20, section 4. So they can represent this to a grand jury. And under that 210-20, there are things that you cannot represent if certain things happen. But judge didn't make that sort of finding. So I don't know. It seems like we'll find out more about this as we get closer to July 24th with the status hearing. So I don't know if the criminal proceeding is done. And I might have assumed it was done if this was all I saw. But I'm not quite sure that it is. So yeah, maybe one of the accounts was actually deficient. Like, I don't know. And I did look it up. I forget exactly the language of it. 224. Or do I have it in the tweet? do New York. Okay, so the basic of the text is Criminal Procedure Law, Section 21020, motion to dismiss or reduce indictment. After arraignment upon an indictment, the Superior Court may, upon motion of the defendant, dismiss such indictment or any count thereof upon the ground that the indictment or count is defective, the evidence before the grand jury was not legally sufficient, the grand jury proceeding was defective, the defendant has immunity with respect to the offense charge. That's not relevant here. Prosecution is barred by any previous prosecution. That's not relevant here. Untimely is not relevant here. Denial of speedy trial right, not relevant here. Let's see. The relevant section. Upon dismissing an indictment or account thereof, upon any of the grounds specified in paragraphs A, B, C, or I. We didn't read I. What was I? Let's read I. Dismissal is required in the interest of justice pursuant to section 21040, 1A, after arraignment upon an indictment, if the Superior Court, upon motion of the defendant, pursuant to the subdivision or paragraph B of subdivision 1 of this section, challenging the legal sufficiency of the evidence before the grand jury, finds that the evidence before the grand jury was not legally sufficient to establish the commission by the defendant of the offense charged in any count contained within the indictment, but was legally sufficient to establish the commission of a lesser included offense, it shall order the count or counts of the indictment, with respect to which the finding is made, reduced to allege the most serious lesser included offense with respect to which the evidence before the grand jury was sufficient, except that where the most serious lesser included offense thus found is a petty offense, and the court does not find evidence of the commission of any crime in any other count of the indictment, it shall order the indictment dismissed and a prosecutor's information charging the petty offense filed in the appropriate local criminal court. I don't think this one's relevant here because they're able to represent to a grand jury with felony. So I don't think that this is going down to just misdemeanors. But it is something that was just part of this relevant section. So it could be A, B, C, or I of subdivision 1, or upon dismissing a Superior Court information or account thereof, upon any of the grounds specified in paragraphs A or I of subdivision 1, the court may, upon application of the people, in its discretion, authorize the people to submit the charge or charges to the same or another grand jury. When the dismissal is based upon some other ground, such authorization may not be granted. So it's probably under one of the grounds above. In the absence of authorization to submit or resubmit, the order of dismissal constitutes a bar to any further prosecution of such charges by indictment or otherwise in any criminal court of the county. So this part's not applicable here because we know the judge has already given permission to refile. So, so wait, count 4 is the only one that lists a failure? Good eye, sniper here. Where was it? All right, which one's count 4? Oh, up the top. Dismiss with leave to represent. Wait, how do you see? Oh, the top count. So the top count would be this one. It's like the third one on the list. Top charge of one. Oh, because it says. So the leave. Where does it say failed to show? Oh, here. Okay. This little bit right here. Let me get the little pen. Right there. Right there. Or is that just fail to show license? Leaving accident with failure to show license. Dismiss and leave to represent. Arraigned, pled not guilty. How do you see that that's the only one that's deficient? Is it the A thing here? Either way, I mean, I think we'll find out in due time what is represented and if it moves forward. So, and again, this is something that has been relevant to the cross sanctions motion because Tyrone Blackburn wanted to sanction Joe Tacopina for bringing up this pending criminal case, this indictment, because Tacopina was like, "You're under indicted." He meant to say indictment. "You're under indictment for these things," and Tyrone Blackburn was like, "No, that's not true." And those statements were made before this recent dismissal. This dismissal happened, I think, on the 28th. Yeah, May 28th. So, but yeah, either way, status hearing for that is July 24th. So, I mean, I didn't really see anyone reporting on it. I think /star saw the picture that was posted on social media, and the best we have to work with is what pops up on this docket. So, okay, yeah, so Missouri dockets will list which counts were insufficient. Yeah, I wish this would. I mean, it's not really the greatest, and he had at some point, maybe it still shows if we look at another window. Let's see. For some time, until this was recently updated in the last week, it still showed the previous charges. So he was initially charged with certain, like, these injury to a process server. I think there was one, like, someone that was over the age of 65, which was removed. The prosecution decided not to pursue that. Maybe that's because they found out the guy's age or something. I don't know. But, like, there were more that have been removed and were, like, rewritten before the charges were formally filed between the arrest and the arraignment. And it used to show all that history, and now it doesn't show that history. So, you know, a web criminal doesn't really have a great paper trail of much of anything. I mean, this is pretty much all you can see. So, kind of balls to look up anything going on in these courts. Not very accessible. So, I wish we had that. But that is what we've got, and I can't believe I was like, "Oh, we're done." And I was like, wait a minute, we have the criminal case update to talk about. So, if you look at it from the news result, it looks like that's done and over with, but I'm not so sure. It seems like prosecution probably just refile and cure the deficiencies and represent to a grand jury. So, we'll see what happens there. Other than that, you guys, sorry I've been putting off the updates in this case for so long. It gets like becomes a complicated mess to file. But I do think it's important to follow. I don't think it's fair. I mean, I think it's my opinion that this is entirely frivolous, and I can't imagine sitting through having to deal with something like this. I could not afford Jordan Sieve. I could not afford Joe Tacopina. I could not afford Alex Spiro. Like, this would ruin my life. So, to know that these headlines went out when the June complaint was filed, when nobody was buzzing or talking about the April filing, that's really what got me interested in this case to start off. And at that point, when I got interested in it, I just thought it was unusual, the coverage, right? Why was this coverage for the June complaint so bombastic, so widespread? And so much of the reporting didn't even mention that another case was active already, previously filed by Fat Joe against not just Terrance Dixon, but Tyrone Blackburn, calling it defamation and extortion. That was missing from the majority of that coverage in June, which I just thought was so unusual with journalism. You know, with the story with journalism, typically you have a repeat back to very old context that comes up with every update in a specific topic. And it was just missing from all of this coverage. So I feel like it's something that went under the radar. Nobody really paid attention to, and they saw this big thing filed in federal court claiming RICO and sex abuse of minors. And I think that was the intent of it being filed that way. And I reserved in my position of the merits of the claim. I was a bit confused why Terrance Dixon was making a claim on behalf of other parties. Like, he's not eligible for damages there, but he was making claims related to other individuals, not himself. So I thought that was weird. But, I gave it some time, and then the way this has gone on and on and on, I'm like, if this doesn't require a beyond reasonable doubt standard, but I feel like I'm at a beyond the reasonable doubt standard that this was not brought in good faith based on what I'm seeing just from the motions and the pleadings. So I've taken a great interest in this case because of the initial media coverage. And the reaction to something salacious is always so loud. And it's like bringing Roc Nation into the mix. If there's already like negative sentiment about Roc Nation going on and other artists, well, if you bring Roc Nation in and claim that they're in some RICO with another celebrity, well, that's going to very easily tarnish the name of that celebrity in the eyes of individuals who are already speaking very loudly against Roc Nation for other reasons, right? Reasons that might have their own merits. But that criticism is just going to, because of the viral nature of the coverage, just come with this inherent and almost instinctive impugning of guilt on the next person accused to have some criminal civil conspiracy affiliation with the same company. And I don't think that I don't like that type of media coverage. I don't like the way that things just go viral because somebody's name is in a headline and it's automatically assumed that we already don't like one thing, so if we hear that someone else is associated with it, they must be doing bad things too. I just think we need to do better as consumers of information, as consumers of headlines. I wish the information was more accessible and easier to follow. And I really, a knock to journalism. Very few outlets were covering or mentioning, when they started to cover the June complaint, the existence, not even in detail, but just mentioning the existence that, hey, Fat Joe claimed defamation and extortion attempts back in April already. That was completely missing in some of these major articles from major outlets. And I think it's very disappointing. So with that being said, I will continue to follow this. I'm glad you guys take an interest in it. I feel like as soon as I leave, I'll see an update or something. Again, a lot of these smaller updates, they happen over on X. I just can't do a stream for every little thing because there's just so much. But if you guys think it's okay to, hey, there's a big motion, but we'll catch up on all the small details right before we read a big motion. If you guys like that format, let me know. We'll do it that way so nothing gets left behind. And other than that, you can always catch the updates in community posts on YouTube or over on X, which I think is easier to search than community posts. So that being said, it was good to see everybody. I missed you guys this weekend. And we'll get back together sometime this week for who knows what. But thanks for tuning in. Have a great day and see you at least next time there is a Blackburn adjacent motion going on. Have a good one, you guys.